1, 2, 1, 2. One, two, 1, 2, 1, 2. One, two, 1, 2, 1, 2.
Mic check 1, 2, 3. 1, 2, 3. All good?
Good morning. A quorum being present, the Committee of Veterans Affairs will come to order. Now, before we begin today, I would like to welcome back, where'd he go? Chris Bennett. Chris is as a staffer, he's doing what staffers do. They're working back and forth. We want to welcome back Chris Bennett, a professional staffer member on the minority staff. Mr. Bennett recently returned back to the committee staff after serving overseas with the U.S. Army. We want to thank you for your service, and we want to welcome you back. He was his... Matt's commanding officer? Okay, good. Really? All right, well, we're meeting this morning to mark up 11 bills. There are amendments in the nature of substitute for 8 of these bills, and that were noticed by the committee. Some of these include texts on other bills that were passed on bipartisan basis at the subcommittee level. Each of these bills we consider today will benefit veterans and their families. We will be considering legislation that would ensure providers who house homeless veterans can provide the necessary support services to bring our veterans out of homelessness and on track to lead fulfilling lives. Make improvements to the law that protects service members who are deployed from losing their jobs to meet the needs of today's fighting force, to restore employee accountability at the VA, to deliver the men and women who have served the level of customer service that they've earned, to continue our commitment to improve the transition assistance program to allow veterans to help transitioning active duty service members and understand that benefits are available to them. Make improvements to facilities that are at a high risk of flooding and increased access to mental health resources for caregivers, improving security within the VA facilities and providing veterans with needed long-term care options, and increase protection for student veterans and beneficiaries by preventing VA from making sudden incorrect decisions. Now, I'm grateful to each of the subcommittees for bringing these thoughtful, well-intended legislation forward to close out the summer session on a high note for our veterans and their families. Now, I would like to yield right now to the ranking member for his opening remarks.
Well, thank you, Mr. Chairman. Several items on today's markup agenda represent the results of bipartisan compromise and hours of staff negotiation. I wish to thank the committee staff for their work to get us to yes on legislation that will benefit homeless veterans and student veterans. I'm also thankful to staff for their dogged and unrelenting efforts to get CBO to look at more data and revise its score on the Elizabeth Dole Home Care Act. This bicameral and bipartisan bill represents some of the excellent work we can do on behalf of veterans if we work together and find common ground. And while I'm supportive of 10 out of the 11 bills on the agenda, I must highlight my concern that we are marking up the so-called Restore VA Accountability Act today. This highly problematic bill has been rushed from introduction to markup in about a month's time. However, I hope we may pump the brakes before any floor consideration of this deeply flawed legislation, which likely has provisions that will prove not only to be unenforceable, but unconstitutional, and therefore of no benefit to veterans or any notion of accountability. I am troubled that last week my colleagues raised the hue and cry about due process concerns when it came to veterans' access to guns, and yet are so unwilling to throw those concerns out the window when it comes to the hardworking civil servants at the Department of Veterans Affairs. It is especially stark when the whole premise of this bill is based on a belief that there simply must be thousands of terrible VA employees out there just waiting to be fired, when I believe there is nothing further from the truth. Of course, any organization might benefit from improvements to supervisor training, performance management, in a more robust human resources function. But no organization can be improved by mass firing and demoralization. We ask a lot of our VA workforce because they serve veterans every single day. But I know the VA workforce appreciates its mission. Over a third of the workforce are veterans themselves. We saw this workforce stand up and deliver care and services during an unprecedented public health emergency, and 259 of those employees gave their lives in that service. I do not believe that people who gave everything for the mission deserve to have rights stripped away from them. This bill is not about accountability, it is about a soundbite. No matter the harm that this political attack creates by undermining veteran trust in VA and disincentivizing Americans from choosing to serve veterans at VA. This is especially troubling at a time when VA needs to hire up for the PACT Act implementation, and while it faces thousands of ongoing vacancies. Who would want to work for an organization where you have few civil service protections as compared to every other federal agency? Where working hard and moving up into supervisory and leadership roles further diminishes your rights and puts you more at risk. Now, I want to remind folks that I voted for the 2017 law, but the last 6 years of litigation and examination by the courts have left me with the conclusion that we were misguided and clearly did a poor job in drafting the law in the first place. I won't compound my mistake here today and vote for another rushed bill that will accomplish little. I'm more than willing to have a very serious conversation about true accountability, and that includes Congress putting some real muscle behind the physical and human infrastructure needed to support a workforce. But I cannot support something that we may as well just call the Attack on VA's Workforce Act. Our veterans deserve better, and the VA employees that serve them deserve better. And I just might add, the constitutional rights involved here are covered by the first 10 amendments. The Fifth Amendment and the 14th Amendment relate to due process and property rights, and I remind my colleagues that employment falls within that rubric. I yield back, Mr. Chairman.
I thank the ranking member. So let's get started today. I now call up H.R. 3848, the Housing Military Veterans Effectively Act of 2023, or the Home Act of 2023 as amended. The clerk shall report the bill.
H.R. 3848.
The bill was circulated in advance and pursuant to committee rules. Without objection, the first reading is dispensed with, and the bill is open for amendments at this point. I now recognize myself for the purpose of offering an amendment. The clerk shall report the amendment in the nature of a substitute.
Amendment in the nature of a
I
substitute.
ask unanimous consent that further reading of the amendment in the nature of a substitute will be dispensed with, and I ask that it be considered based as the base text for the purpose of the markup. Without objection, so ordered. I now recognize myself for 5 minutes to speak in support of the amendment in the nature of a substitute. You know, we've heard a number of comments over the past few months from the other side of the aisle, especially at our last full committee markup about how Republicans do not care about homeless veterans. I trust that this amendment is in the nature of a substitute, and legislation would be put at that talking point to rest. This amendment will ensure that our community providers that provide transitional housing for homeless veterans would have the funding to carry out what is needed to service our veterans. This issue has been an active discussion on both sides of the aisle for months. As a result, this amendment in the nature of a substitute is a bipartisan compromise that listens to the views of stakeholders and the VA to effectively bring more veterans out of homelessness into a physical responsible manner. My amendment, I also include Representative Chirfilis and McCormick that was marked up in the committee earlier this year. That bill would ensure that homeless veterans can get to medical appointments and receive assistance with necessary hygiene items. Now, I'm pleased to include that bill in this proposal today with minimal changes, and I thank her for her leadership. and on this issue. Finally, this amendment is in the nature of a substitute, is fully offset by extending the current VA home loan funding fees to May 2032. This is a bipartisan offset that we have used in the past and is supported by the veteran service organizations. I encourage my colleagues to support my amendment. With that, I yield back. And do any other members wish to comment on the amendment in the nature of a substitute to H.R. 3848?
Mr. Chairman, I seek recognition.
Ranking member.
I'd like to thank the chairman and his staff for the work they have done with me and my staff to come to an agreement on this bill. And this talking point is put to rest. Sort of. I would like to also...
I'm sure to come up later.
I would also like to thank Ranking Member Levin and Chairman Van Orden for the important work on the Economic Opportunity Subcommittee that has been working on the homelessness issue. I know that addressing veteran homelessness is Mr. Levin's top legislative priority in our committee, and his work continues to create progress. I think we're all well aware that the enhanced flexibilities to address veteran homelessness given to VA during the COVID pandemic lapsed earlier this year. My Democratic colleagues and I have been pretty clear how concerned we are about this lapse, especially seeing how effectively the flexibilities impacted last year's point-in-time count. I've been disappointed with the lack of urgency to address the gaps and shortfalls in homelessness authorities since the COVID pandemic emergency authorities expired. I have called for the passage of Representative Shurflis McCormick's and Representative Williams' legislation, and I'm worried that the lack of movement to make some of these flexibilities permanent is going to increase the number of homeless veterans. While I agree with the veteran homelessness advocates and VSOs that the grant and per diem rate should be set at 200%, like in Rep. Williams' bill, H.R. 491, I appreciate the effort my Republican counterparts appreciate the effort of my Republican counterparts to compromise, and I will be supporting the amendment in the nature of a substitute. The most important thing is getting this change into law as soon as possible so that providers can receive reimbursement and continue serving veterans, especially in high-cost areas. Because of the urgency and the gap in funding since the lapse of COVID authorities, I will be urging House leadership and the Senate to move this bill as quickly as possible so that it can get to the President's desk for signature. At the end of the day, we are here to share we here share the same goal of ending veteran homelessness, and we can argue about authorization levels, about the efficiency or effectiveness of programs, and about funding levels with the appropriations committees, but any homeless veteran deserves to be sheltered. If a veteran remains on the streets, sleeping in their car or couch surfing for a single night, we know we have more work to do to oversee outreach and funding of VA's homelessness programs. We can't solve this problem until we address the lack of affordable housing in this country, gaps in opportunity and underemployment, and challenges for those Americans on a fixed income. If we are housing 40,000 veterans each year, but the same number are becoming housing insecure, we are just running on a treadmill. So I urge the adoption of the amendment in nature of a substitute. I urge a yes vote on the bill, and I urge swift passage on the floor. And I yield back, Mr. Chairman.
Thank you, Mr. Ranking Member. Representative Shifless McCormick, you are recognized for 5 minutes.
Thank you so much, Chairman Boss. I would like to first off by thanking you again, Chairman Boss, for introducing this amendment that includes Representative Nikema Williams' bill, H.R. 491, the Return Home to Housing Act, and my bill, H.R. 64, the Healthy Foundations for Homeless Veterans Act. And a large thank you to both the majority and minority committee staff for working together to solve the veterans' homelessness. Without everyone's hard work, this would not be possible. It is paramount that this amendment passes and proceeds to the House floor as soon as possible, since the VA's flexibilities to keep chipping away at homelessness has expired nearly 3 months ago on May 11th at the end of the public health emergency. With the use of the now expired flexibilities, the VA has permanently housed over 40,000 homeless veterans. It has provided more than 400,000 rides for over 40,000 homeless veterans, getting them to and from medical appointments and to job interviews and to get back on their feet. We heard from a VA official back on March 30th that stated, and I quote, "I don't think it's possible to completely and totally end veteran homelessness without the flexibilities and keep veterans from falling through the cracks. I unequivocally urge my colleagues to vote yes on Chairman Boss's amendment, and I yield back. Thank you."
Thank you, Representative. Mr. Sisamani, you're recognized for 5 minutes.
Thank you, Chairman Boston. Thank you for yielding time for me to speak on your continued leadership here. Also, thank you for that here at the House Veteran Affairs Committee. As a member of the Economic Opportunity Subcommittee, I am pleased to see Bill H.R. 3848, the HOME Act, before the full committee for consideration. This legislation, introduced by my friend Representative Lori Chavez-Dramer, would increase the per diem rate from 115% to 133% to assist nonprofit organizations who help our homeless veterans find transitional housing. In addition, this legislation gives the VA flexibility to increase the per diem rate up to 200% for community providers truly in need. This is incredibly important for my district and the veterans at risk of becoming homeless in southern Arizona, southeastern Arizona. According to a 2022 report from the Department of Housing and Urban Development, my home county, Pima County, and the city of Tucson have one of the highest rates of homeless individuals unable to find any temporary housing, leaving roughly 74% unable to find shelter. While those numbers are not exclusive to the veteran population, these numbers do highlight the fact that our community needs additional help to support those who served this country and that are struggling. I am proud to support this legislation, and I look forward to working with my colleagues to ensure those who fought for this country can feel secure with a roof over their head. Thank you, sir, and I yield back.
Gentleman yields back. Mr. McCarvey, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I look forward to the bipartisan passage of this much-needed piece of legislation. Let's be clear, no veteran, no individual who ever puts on a uniform, no person should be unhoused in this country. We are the richest nation in the history of the planet. We are more than capable of leveraging the great resources of this country to solve homelessness, especially for our unhoused veterans. I look forward to the day that this legislation is unnecessary. In the meantime, this legislation, as amended, provides critical changes to ensure that entities providing shelter and resources have the support they need from the VA. I urge its passage, and I yield back.
Does anyone else seek recognition? Mr. Benron.
Thank you, Mr. Chairman, and thank you, Ranking Member Takano. I appreciate it, and all my colleagues here. I have an amendment at the desk.
We are right now commenting on the bill. We'll get to that.
I stand corrected.
Seeking recognition to comment on the original bill. Seeing none. Now, no other member having filed no other amendment being filed, does any member wish to offer an amendment to the amendment in the nature of a substitute to H.R. 3848? The question now occurs on agreeing to the amendment in the nature of a substitute for H.R. 3848. All those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it. I now recognize Ranking Member Takano for a motion.
Mr. Chairman, I move that that H.R. 3848 as amended be reported favorably to the House.
The question is favorably reporting the bill of H.R. 3848 as amended to the full House. All those in favor say aye. Aye.
Aye.
Opposed say no. In the opinion of the chair, the ayes have it, and the motion is agreed to. H.R. 3848 as amended is reported favorably to the House.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority, supplemental, additional, or dissenting views on H.R. 3848 as amended.
Without objection. Now call up H.R. 3943, the Service Members Employment Protection Act of 2023 as amended. The clerk shall report the bill.
H.R. 3943.
Text was circulated in advance pursuant to the committee rules, and without objection, the first reading of the is dispensed with. The bill is now open for amendment to any point. I now recognize Representative Franklin for the purposes of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment in the nature of a substitute.
Amendment in the
I
nature.
ask unanimous consent that the further reading of the amendment in the nature of a substitute be dispensed with. I ask that it be considered base text for the purpose of this markup. Without objection, so ordered. Now, I now recognize Mr. Franklin, Representative Franklin, for 5 minutes to speak in support of his amendment in the nature of a substitute.
Thank you, Mr. Chairman. My amendment in the nature of a substitute would make recommended technical changes made by the GAO regarding the report on USERRA. I believe these changes make the bill stronger, and I urge members to support my amendment, and I yield back. I yield back.
You yield back, okay. I thank Representative Franklin for his amendment in the nature of a substitute and for introducing a bill that finds common ground between service members and the businesses. I also want to thank the Reserve Organizations of America and the other military service organizations for providing critical input on these issues earlier this year to help craft this bill. It has my full support. Do any other members wish to comment on the amendment as a nature of a substitute to H.R. 3943? Ranking member?
Mr. Chairman, I have an amendment to the amendment in the nature of a substitute at the desk.
Are there, well,
Oh, I'm sorry.
are there any other amendments to the nature of the substitute at H.R. 3945? Ranking member now.
Yeah, Mr. Chairman, I have an amendment to the amendment in the nature of a substitute at the
The
desk.
clerk shall report the amendment in the nature of a substitute.
Amendment to the amendment in the
I ask unanimous consent to further reading of the amendment and is dispensed with, and hearing no objections, so ordered. The ranking member is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. As we continue to see an increased utilization of the reserve components by the Department of Defense, we must continue to increase support and protection for Reserve and National Guard service members. From our hearings in the 116th and 117th Congresses, we know that these service members are being asked to do significantly more than the traditional 1 weekend a month and 2 weeks in the summer. With more time away from home, their families, and from work, there is concern that bad actor employees may punish service members for this increased time away. It is the responsibility of this committee to ensure that service members are protected and employers are held accountable, to include the federal government and specifically intelligence agencies. Mr. Chairman, my amendment adds the Justice for All Service Members Act to the end of the underlying bill. This would prohibit employers from requiring National Guard or reservist employees to agree to the use of forced arbitration to resolve USERRA complaints as a condition of their employment. This is a tactic used by corporations to strong-arm employees and prevent USERRA complaints from being resolved fairly and openly, effectively ensuring a worse outcome for the service member than they would have under a traditional USERRA complaint. It also prevents public acknowledgement of the employee's disgraceful behavior and the ability for enforcement agencies to identify habitual offenders. I wish I could give you a list of which employers used forced employment arbitration clauses, but unfortunately, these agreements are signed in secret. What we do know is this: over half of private sector workers are subject to forced arbitration clauses, and this committee has heard directly from service members from all branches who have been harmed by forced arbitration. Obviously, the Chamber of Commerce is opposed to this amendment because they are advocating for bottom lines. But protecting bad actor corporations' bottom line is not our job as members of Congress. Our job must be standing up for our service members. Every one of us loves to talk about how we support troops and veterans on Memorial Day, Veterans Day, and on the campaign trail. Here is an opportunity to prove it. Will we vote in favor of protecting service members' right to reemployment? For members of the full committee who might not be familiar with USERRA, it came up at the March 9th Economic Opportunity Subcommittee Oversight hearing and the June 14th legislative hearing. I know some of the new members on the committee were surprised by the witnesses, stating that USERRA complaints are one of the top issues for the Guard and reservists. The committee has received a letter from 20 veteran service organizations, including the American Legion, VFW, the Enlisted Association of the National Guard of the United States, the National Guard Association of the United States, and the Reserve Organization of America, highlighting the need for supporting my amendment. Mr. Chairman, I ask that it be entered into the record.
Without objection.
Now, having served on this committee for over 10 years now, I will tell you this problem is that bad, and I will echo Mr. Van Orden's closing remarks from the March 9th hearing. USERRA is a national security issue. And I will end with this: forced arbitration harms the employment prospects income, and finances for service members and their families in all of our districts. And I urge support for the adoption of the amendment, passage of the underlying bill, and I yield back, Mr. Chairman.
I thank the gentleman for yielding back. I recognize myself for 5 minutes in opposition to the amendment. While I strongly support you, Sarah, I have major concerns with this amendment. The committee voted on this issue last Congress when the minority was in charge and held the House, the Senate, and the White House. The minority passed it out of committee on a party line vote and still didn't move to enact it. The majority has not asked us to hold, the minority has not asked us to hold a legislative hearing on this bill or raised it as an issue until 2 days ago. While it is, my guess is that my guess is that this issue is much more complicated than the minority would like to admit. The amendment would make an agreement to arbitrate a claim under USERRA unenforceable unless all parties consented to arbitration. This is even if the service member signed an arbitration agreement as a condition of employment. A February 2021 GAO report found a lack of sufficient evidence to prove that service members were being negatively impacted by the arbitration agreements. So this amendment seeks to solve a problem that does not exist. GAO specifically stated, although we reviewed federal court cases that upheld the enforceability of these clauses, the Department of Justice officials said mandatory arbitration clauses have not prevented DOJ from initiating lawsuits against the employers and other business under USERRA. The GAO also found that in most cases, DOJ and DOL resolved mandatory arbitration issues by simply explaining the rights of the service member to the employer. Arbitration is also often easier and faster way for service members and a cheaper way to resolve an issue than a lengthy court proceeding. Now, I believe that this amendment is unnecessary and would be a poison pill. I encourage my colleagues to oppose the amendment, and I yield back. Does any other member wish to comment on the amendment to the amendment in the nature of a substitute offered by Ranking Member Takano? Seeing none, the question now occurs on the amendment and the amendment in the nature of a substitute. All those in favor say aye. Aye. All those opposed say no. No. In the opinion, the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman,
Ranking Member?
I call for a recorded vote.
A recorded vote has been requested, and pursuant to committee rules, the vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute? Hearing none, the committee will now consider H.R. 3874. Where are we going here? One more page. Okay. So now I will call up H.R. 3874, the Veterans Education Assistance Improvement Act. The clerk shall report.
H.R. 3874, to amend Title 38, United States.
The text was circulated in advance pursuant to committee rules and without objection. The first reading is dispensed with, and the bill is now open for amendments at any point. I now recognize Mr. Representative Van Orden for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. Sorry for that rookie move previously. I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3874.
I ask unanimous consent that the further reading of the amendment in the nature of a substitute is dispensed with, and I ask that it be considered base text for the purpose of this markup. Without objection, so ordered. I now recognize Representative Van Orden for 5 minutes to speak in support of his amendment in the nature of a substitute.
Thank you, Mr. Chairman and my fellow colleagues. My amendment in the nature of a substitute would make several positive changes to H.R. 3874, the Veterans Education Assistance Improvement Act, originally offered by Mr. Rosendale. Specifically, this bill would make it easier for student veterans to receive their monthly housing allowance during their final semester in college by reducing the number of classes students veterans would need to take if they didn't need to be a full-time student. This bill would also prevent VA from making radical changes overnight and would make sure that they notify Congress, schools, and most importantly, the veterans of any changes to the GI Bill. This would also include technical fixes to Mr. Buchanan's bill, H.R. 6604, from the 117th Congress. Since H.R. 6604 was signed by the President last December, VA has been unable to restore student and beneficiary GI Bill benefits before going back to 2021. This technical fix would give them the authority to finally do so. Last, I'm happy to see my friend and colleague, Mr. Crane's proposal, the Transcript Assurance for Heroes Act, included in this legislation. This proposal would ensure student veterans are protected from school closures because they would already have a transcript necessary to continue their education elsewhere. H.R. 3874 is amended as a result of a bipartisan negotiation through my subcommittee over the last few months, and I'm pleased to see revisions offered by the Department of Veterans Affairs and supported by the minority included in H.R. 3874 as amended today. I urge all the members to support H.R. 3874 as amended, and I yield back.
I thank Representative Van Orten for his comments and to see the legislation through his subcommittee. And I would also like to thank Representative Rosendale and Crane for introducing their bills included in this amendment in the nature of a substitute. You know, this amendment in the nature of a substitute provides necessary protections for student veterans while also cutting bureaucracy and red tape. This proposal would also decrease government spending without cutting the veterans' benefits. It has my full support. Do any other members wish to comment on the amendment in the nature of a substitute to H.R. 3875?
Mr. Chairman.
Ranking member?
Mr. Chairman, I support the ANS and the underlying bill. These changes have been advocated by VA, veteran service organizations, student veterans, and educational institutions to help improve the implementation of the Isaacson-Rowe package Congress passed a few years ago. I think these changes complement the work being done by Ranking Member Levin and Representative McGarvey, and I appreciate the bipartisan work being done in the Economic Opportunity Subcommittee. I urge support, and I yield back.
Thank you, Ranking Member. Any other? Mr. Rosendale.
Thank you very much, Mr. Chair. Mr. Chair, my bill, H.R. 3874, the Veterans Education Assistance Improvement Act, cuts red tape for student veterans when receiving their benefits. My bill would make the VA decisions that harm student veterans less likely to occur going forward. My bill would also allow Congress to be proactive instead of reactive by being able to solve potential problems before veterans suffer. Under the current law, veterans must take a full course load to receive their military housing allowance, regardless of how many classes are needed to graduate. This places an unnecessary burden on these veterans by requiring them to take additional classes that are not necessary for their degree. This also costs the taxpayer more money. My legislation would remove this provision and give veterans the choice of how many classes they wish to take in their last semesters. Veterans should be able to make the best decisions for themselves and for their families. Moreover, my legislation would require the VA to notify Congress, educational institutions, and students of any changes not subject to the Congressional Review Act that would impact these student veterans 120 days in advance. My legislation would stop future problems before they become full-blown crisis for student veterans by requiring sufficient notice to allow stakeholders adequate time to weigh in. It also strikes an appropriate balance because the notice will not delay a potential good change for too long. This legislation also includes my good friend Congressman Eli Crane's Transcript Assurance for Heroes Act. His bill would require schools receiving educational assistance to provide digital official transcripts for GI Bill beneficiaries. His bill is common sense, pro-veteran legislation, and I am pleased that it's been packaged with mine. First established in 1944, the GI Bill has resulted in millions of qualifying veterans and their families receiving money to cover some or all of the costs for school training. It is one of the most successful government programs in history. The GI Bill is also a rare government program that has generated a massive return on the initial investment. We owe it to our veterans to have an education system that is easy to understand and that works for them. My legislation builds on the past successes of the program cuts red tape, and moves our country closer towards showing the veterans the compassion and respect that they deserve. Thank you, Mr. Chairman, and I yield back.
Gentleman yields back. Is anyone else seeking recognition? Seeing none, the question now occurs on the amendment in the nature of a substitute to H.R. 3874, offered by Representative Van Orden. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. Without objection, the motion to reconsider is laid on the table. I now recognize Ranking Member Takano for a motion on reporting H.R. 3874 as amended.
Mr. Chairman, I move that H.R. 3874 as amended be reported favorably to the House.
The question is favorably reporting the bill H.R. 3874 as amended to the full House. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. The motion is agreed to, and H.R. 3874 as amended is reported favorably to the House.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority supplemental, additional, or dissenting views on H.R. 3874 as amended.
Without objection. I now call up H.R. 3933, the TAP Promotion Act. The clerk shall report.
H.R.
The
3933.
bill was circulated in advance pursuant to committee rules, and without objection, the first reading is dispensed with, and the bill is open to amendments at any point. H.R. 3933 would require VA to allow veteran service organizations to present information about accessing benefits during the Transition Assistance Program to service members. This would help service members understand the benefits available to them after they leave the military. Now, this would also allow them to connect with the veteran service organizations during their transition to civilian life. Now, Representative Van Orden's legislation is about veterans helping future veterans. The Department of Defense has granted access to military bases past, but access has been denied in some locations in recent years. This bill would address that conflicting policy head on and encourage the Department of Defense to allow VSOs on the base as a way to prepare transitioning service members for a life without a uniform. Now, I urge my colleagues to support H.R. 3933, and I yield back. Do any other members wish to comment on H.R. 3933? Mr. Van Orten?
Thank you, Mr. Chairman. I rise in support of my legislation, the TAP Promotion Act. This bill will make badly needed changes to the Transition Assistance Program by allowing veteran service organizations on base to discuss service members' benefits and how VSOs can help service members as they transition out of the military. This committee has seen the positive impact of connections from one service member to the next as they move from being a productive member of the military to a productive member of civilian society. TAP by itself does not give service members the information in a way that is digestible during one of the most difficult periods of their service. However, having a congressionally chartered VSO representatives take the time during TAP to give this information in a different way, it would be critical to ensure our service members' success. And I'll be frank with you, it pains me to say that as a veteran myself, but without further congressional prodding, the Department of Defense is not preparing our service members adequately. I urge all of my colleagues to support this legislation, and I yield it back.
Thank you. Does any other member seek recognition?
Mr. Chairman.
Ranking member?
Mr. Chairman, I appreciate the advocacy of the VSOs to play a larger role in the transition process. Obviously, we all have spoken to the importance of TAP for service members and veterans, and helping connect veterans directly to resources is something Congress, to resources. It's something that Congress, the administration, DOD, the VA, and VSOs are all trying to accomplish. This bill is a step in that direction. I support the bill, and I yield back.
Thank you, Ranking Member, for his comments. Or any other members wish to comment? Seeing none, no amendments were filed. Does any other member wish to offer an amendment to H.R. 3933? Seeing none, I now recognize Representative Takano for a motion.
Mr. Chairman, I move that H.R. 3933 be reported favorably to the House.
The question is favorably reporting the bill H.R. 3933 to the full House. All those in favor say aye. Aye. All those opposed, no. Independent chair, the ayes have it. The motion is agreed to, and H.R. 3933 is reported favorably to the House.
Mr. Chairman, Pursuant to House Rule 11, Clause 2, I give notice of intent to file minority, supplemental, additional, or dissenting views on H.R. 3933.
Without objection. I now call up H.R. 4278, the Restore the Department of Veterans Affairs Accountability Act. The clerk will report.
H.R.
The
4278.
bill was circulated in advance pursuant to the committee's rules, and without objection, the first reading is dispensed with, and the bill is open to amendment at any point. The Restore VA Accountability Act would give the Secretary the authority needed to make the department an organization that is truly accountable to its employees and our veterans. The vast majority of the VA employees I meet are employees are inspiring. They really are. They put veterans first. Unfortunately, there are a small number of VA employees who hurt veterans by harming the quality of care and benefits that they receive. Now, the Secretary must be able to remove, demote, or suspend these VA employees who stand in the way of progress at the VA. And I'm going to quote a friend of mine who I used to play basketball in the morning with and cards in the evening with. Guy, you may know him, his name's President Obama. In 2014, here was what he said, and I quote, "After signing the Veterans Access, Choice, and Accountability Act of 2014, President Obama said VA Secretary must have," this is a quote, "the authority so that he can move quickly to remove senior executives who fail to meet the standards of conduct and competence that the American people demand. If you engage in an unethical practice, if you've covered up a serious problem, you should be fired, period. It shouldn't be difficult," end quote. The message is still true today. In 2017, Congress acted on a bipartisan basis to give VA leaders the authority they needed to stand up for whistleblowers' rights, protect employees' rights, always put veterans first, and discipline those who harm veterans. Sadly, administrative court decisions have disregarded congressional intent earlier this year. These decisions and a poor decision, I think, by the Biden administration made VA's Accountability Act authorities unusable. It is time for Congress to get off the sidelines and do something about it. To my colleagues on the dais, do you want to build a VA where people want to work, has a great culture, and provide outstanding care and benefits to our veterans? I believe you do. We simply will not reach that goal if the bad apples are not held accountable. As a committee, we should not be satisfied with a status quo that tolerates a system in which mountains of disturbing evidence is not enough to properly discipline a GS7 supervisor that has a pile of charges against that person. Nor should we be satisfied with a toxic senior executive or an ineffective GS15 DC bureaucrat. I know I'm not. We owe it to the hardworking VA employees and our veterans to hold those at the VA not doing right and not doing the right thing accountable. Lastly, I'd like to thank the brave whistleblowers who have reached out to our team daily. Many of them are veterans and are living out their oath to the Constitution. You inspired this legislation, and you're inspiring to us to make the VA a better place. Now, I am committed to ensure the VA has the tools it needs to discipline bad employees. I'm equally committed to ensuring that the VA whistleblowers are protected. Now, I urge my colleagues to support H.R. 4278, and I yield back. Do any members wish to comment on H.R. 4278?
Mr. Chairman? Mr. Chairman, I have an amendment at the desk.
We're on comments right now. Okay, now we're ready to go to comment. Okay, no one else seeking comment. Mr. Levine, I understand we have several amendments. I want to say that first off. So we're going to move through them as well as we can. I recognize Representative Lean for the purpose of offering an amendment.
Thank you, Mr. Chairman. My amendment would strike provisions of H.R. 4278 that would lower the evidentiary standard that must be met for disciplinary action against VA employees. Specifically,
Clerk will report the amendment. Oh, I'm sorry, you were not finished. I apologize.
okay to continue?
I got it. Here you go.
Good.
Proceed, please.
Specifically, my amendment would strike language that says disciplinary actions only need to be supported by substantial evidence and replace it with language requiring that actions be supported by a preponderance of the evidence. Under a preponderance standard, VA must prove that it's more likely than not that an employee engaged in misconduct warranting disciplinary action. Under substantial evidence standard, VA only needs to provide enough evidence to support a disciplinary action that a reasonable person might find adequate, even if another reasonable person might disagree. For example, if 3 witnesses confirmed alleged misconduct, but 7 denied it, the disciplinary action would still be upheld. This opens the door to biased retaliatory actions against VA employees. I'm concerned about the chilling effect it'll have on whistleblowers, creating an environment where employees are too scared to speak up about wrongdoing that negatively affects veterans for fear of losing their jobs. Disciplinary actions that VA has undertaken with a substantial evidence standard since enactment of the VA Accountability and Whistleblower Protection Act of 2017 have been challenged repeatedly in the courts. In these cases, the Federal Circuit has found the substantial evidence standard to be inappropriate for administrative decisions. Further, the court has stated that there is no precedent for such a substantial evidence standard, citing Supreme Court jurisprudence. There's no reason to believe that opinions will be any different when H.R. 4278 is challenged in the courts. So I urge my colleagues to support this amendment, which will ensure basic fairness to disciplinary actions at VA, the same fairness we afford to employees of every other federal agency. With that, Mr. Chairman, I yield back.
The gentleman yields back for purposes of properly handling this. We kind of jumped the gun. Representative, do you have an amendment at the desk? Then the clerk will report the amendment.
Amendment to H.R. 4278, offered by Mr. Levin.
I ask unanimous consent that further reading of the amendment is dispensed with and without objection so ordered. Now, because the representative, your comments are in place, and thank you for your...
I won't go through the whole spiel again. I'll spare you that. I'll spare you that.
The gentleman yields back. I recognize myself in opposition to the amendment. The amendment attempts to slow down the disciplinary process by changing the Restore VA Accountability Act's substantial evidence standard to a preponderance of evidence standard. As drafted, the Restore VA Accountability Act would require initial fact finder to reveal any disciplinary action and determine by a multitude of evidence that an individual is guilty of misconduct or poor performance. After the fact finder has invested considerable time and effort determining guilt and an appropriate punishment, the secretary and reviewing bodies afterwards would review whether the initial fact finder's decision is supported by substantial evidence. In other words, whether the decision was responsible. If a fact finder decision is not responsible, however, the secretary should overturn the decision and ensure the employee is protected from any unfair or biased fact finder. The fact finder put in the time to investigate and recommend discipline. The secretary and the reviewing bodies should absolutely review the decision, and if it is unreasonable, it should be overturned to protect the employee from unfair or biased fact finders. But they shouldn't simply forever repeat the investigation at the same evidence standard that has already been applied. The substantial evidence review standard is the standard Congress agreed to put in place in 2017, and nothing has changed. That's why I opposed the amendment, and I yield back. Does any other member seek recognition?
Mr. Chairman.
The ranking member.
Mr. Chairman, as I said at the outset, this bill is problematic. Unfortunately, no changes were made after the legislative hearing 2 weeks ago to address the lack of data about the implementation of the 2017 law or the enforcement concerns raised by VA and stakeholders. This committee received a letter yesterday signed by 12 unions who are concerned that this legislation will undermine the collective bargaining agreements and negatively impact recruitment and retention at VA. And I ask unanimous consent to enter it into the record.
Without objection.
Thank you, Mr. Chairman. However, I would say more troubling to these stakeholders and to me is nothing was changed to address the constitutional due process concerns with this bill. The Constitution and due process were the subject of debate in last week's legislative hearing related to access to firearms. I asked for a more detailed discussion about the due process concerns some have expressed about the fiduciary program, and I would hope to hear the same type of engagement in this case, where a bill is being proposed that would strip due process rights from civil servants. That is why my colleagues and I have submitted many of these amendments today. And I would remind my colleagues, these due process concerns are constitutional concerns. And I said constitutional concerns involving the Fifth Amendment, which, as you know, is among the first 10 amendments of the Constitution, and our 14th Amendment. So I support all of the amendments that my Democratic colleagues are putting forward, and I hope that my colleagues will support them as well.
And the gentleman yields back.
I yield back.
Any others want to seek recognition? Hearing none, the question now occurs on agreeing to the 11th Amendment, number 4, to H.R. 4278. All those in favor say aye.
Aye.
All those opposed say no. No. In the opinion of the chair, the noes have it.
Mr. Chairman, I request a recorded vote.
A recorded vote has been requested pursuant to committee rules. This vote will be postponed. I now recognize the ranking member for purposes of offering an amendment.
Mr. Chairman, I have an amendment at the desk to H.R. 4278.
The clerk will report the amendment.
Amendment to H.R. 4278.
I ask unanimous consent that further reading of the amendment be dispensed with and without objection, so ordered. Ranking Member Takano, you're recognized for 5 minutes to explain your amendment.
Thank you, Chairman Bost. My amendment would strike provisions of H.R. 4278 that would prohibit VA from applying certain criteria to evaluate the reasonableness of a disciplinary action. Specifically, my amendment would strike existing language that would limit VA to applying only certain criteria and replace it in each instance with what are known as the 12 Douglas factors. It would require VA to apply those 12 criteria, but not limit the department to only consider those criteria. The Douglas factors are criteria developed by the Merit Systems Protection Board, or MSPB, to evaluate the reasonableness of disciplinary actions and prevent federal workers from being overly penalized when disciplinary action is taken against them. The name Douglas was taken from a 1981 MSPB case involving 7 different employees from 4 different federal agencies, one of which was VA. It is a misconception that the Douglas factors can only be used to mitigate, reduce a proposed penalty against a federal employee. In fact, they can be used both to reduce or increase the penalty. For example, after considering the Douglas factors, a longtime employee with no past disciplinary record and excellent past performance ratings would likely receive a lesser penalty than an employee with repeated disciplinary issues and a poor performance record. Now, I can't really make any rhyme or reason out of which Douglas factors the chairman opted to include versus exclude when drafting this legislation. The chairman's bill would explicitly prohibit VA from considering 10 out of 12 Douglas factors, including past disciplinary history for senior executives, supervisors, and management officials. It would bar VA from considering 7 out of 12 Douglas factors for rank and file employees. Among the factors VA would be barred from applying for all groups of employees are a consideration of how consistent the penalty is with those imposed upon other employees for the same or similar offenses, the clarity with which the employee was on notice of any rules that were violated or had been warned about the conduct in question, and the potential for the employee's rehabilitation. Limiting the application of the Douglas factors would strip VA employees of due process rights and civil service protections that are afforded to other federal employees. Further, and equally concerning, it would effectively absolve VA supervisors from the responsibility of actively engaging in performance management on an ongoing basis. This includes setting clear expectations up front, giving employees feedback when they are underperforming, and documenting performance improvement plans. Performance management is a two-way street, and it is only fair that managers be held as accountable for their engagement in the process as we wish to hold employees in their delivery of VA's mission. With that, Mr. Chairman, I yield back.
The gentleman yields back. I recognize myself now in opposition to the amendment. The amendment would require VA to apply all 12 of the Douglas factors when determining which disciplinary action is appropriate. Now, the Douglas factors have never been codified in law since they were invented by an unelected bureaucrats in 1981. For over 40 years, the VA employees have been judged according to factors that have no basis in statute and no input from elected officials. First, I appreciate that this amendment agrees in principle that these disciplinary factors should be codified in law. However, requiring VA to look at all 12 of the current factors would mean including factors that are clearly inappropriate, like the reputation of the agency. My bill, as written, would codify the most relevant factors and would discard unnecessary ones that open up avenues to slowing down the already incredibly slow process. The Restore the VA Accountability Act would put veterans first, not the reputation of the VA. That's why I oppose this amendment, and I yield back. Does any other member seek recognition? Representative Rosendale, are you recognized at this time?
Thank you very much, Mr. Chairman. Mr. Chairman, I would like to address the underlying bill. Your VA Accountability Act will hold bad employees that compromise veteran safety accountable. That's what we're focused on. And I am proud to be a co-sponsor of that bill. In 2017, President Trump signed the Department of Veterans Affairs Accountability and Whistleblower Protection Act. It was one of President Trump's incredible initiatives to help our veterans. The bill passed the House in an overwhelming bipartisan fashion by a vote of 368 to 55. A major component of the law was making it easier for the VA to remove poor-performing senior executives and replace them with qualified candidates. The legislation was working. It led to a 50% increase in removal and discipline actions, which played a significant role in VA-wide trust scores, increasing from 59% in 2016 to 80% in 2020. That is the definition of success. On April 3rd, 2023, the VA decided it will no longer use the law to hold bad employees accountable. The decision was made because of politics, not what was beneficial for veterans. This was a slap in the face to Congress and the separation of powers. Congress, not the VA, makes the law. The American Legion, the VFW, SVA, AWP, CVA, NGAUS, and EANGUS all support this legislation. Many spoke or submitted statements of support during our legislative hearing on this bill. While the VA opposes the legislation, veterans support the bill. This is another example of the VA putting its own interest above the veterans. Here's a report right here from the problems reported at Fort Harrison, dated July of 2023. So we're not talking about something that is old. It's from Helena, Montana, which states, and I quote, "We found violations of VHA policy and a significant risk to public health and safety." A significant risk to public health and safety related to the previous employee practice and oversight of programs intended to ensure continued competence of credentialed and privileged providers. So clearly, this is necessary. The core function of the VA is to provide world-class health care and benefits for our nation's heroes, and Chairman Boss' legislation helps us achieve that goal. Thank you for allowing me to speak, and I yield back.
Gentleman yields back. Does anyone else seek recognition? Seeing none. The question now occurs on agreeing to the Takano Amendment number 5 to H.R. 4278. All those in favor will say aye. All those opposed will say no. No. In opinion of the chair, the noes have it.
Mr. Chair.
The noes have it, and the amendment is not agreed to. I now move on to recognize Representative Landsman's for the purpose of offering an amendment.
Thank you, Mr. Chair. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 4278, offered by Mr. Landsman. Page 3.
I ask unanimous consent that further reading of the amendment is dispensed with. Without objection, so ordered. Representative Landsman, you are recognized for 5 minutes to amend on your amendment.
Thank you, Chairman Boss. My amendment would strike provisions of H.R. 4278 that would deny employees the right to be put on performance improvement plans prior to disciplinary actions being taken. So this is very straightforward and hopefully will be supported by both my Republican and Democratic colleagues. This provision simply allows, or striking it would allow folks to have due process. If there is an issue, the staff member would have the ability, as most Americans do, to address that issue, and if it's not addressed, obviously they have to move on. I'm offering this amendment for a couple of reasons. One, these are veterans. 25, 30% of our employees are veterans. We're talking about 90 to 100,000 employees that are veterans, and they deserve due process. But they're all Americans, and protecting employees is something that I know to be true is bipartisan. That is something that I think we can all agree on. Accountability and being able to root out truly problematic folks at the VA, very important, offering due process, or at least protecting due process, which, as it's been mentioned, is a constitutional issue, is something I hope we can all agree on. Finally, the recruitment question is a big one. How are we going to continue to recruit folks, increase staffing levels, if people know that the VA is one of the only places where you don't get due process, where you're not going to get a performance improvement plan? That is going to make it very difficult for folks to recruit and staff up and support our veterans. So my hope is that this amendment, which strikes a very simple provision, will be supported by both Republicans and Democrats, and with that, I yield back.
Gentleman yields back, and I recognize myself in opposition to the amendment. Performance improvement plans are important tools to develop employees and help them understand what is expected of them. The Restore the VA Accountability Act simply states that the Secretary may choose not to enter into a performance improvement plan before taking disciplinary action. This amendment would take away the important flexibility that the Secretary would have. The Restore the VA Accountability Act would replace other disciplinary authorities. It would simply be another tool for VA to use when traditional authorities are not sufficient to discipline an employee who is clearly deserved. Hold on. Script is messed up, so let me say it this way. When the discipline that the employee is clearly in having a problem and is affecting negatively our veterans are going to be first over the employee. In a situation where a bad employee needs to be removed quickly, and there are those times, VA should not be forced to drag out the disciplinary process because of an inflexible performance improvement plan requiring while a toxic employee is harming our veterans around them. That's just not right. So I oppose the amendment and I yield back. Does any other member wish to make comments on this amendment? Seeing none. The question now occurs on the agreement of the Landsman Amendment to number 8 to H.R. 4278. All those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the noes have it. This amendment is not agreed to. I now recognize Representative Cheffersilis, I'll get this right someday, I really will, Cheffersilis McCormick, for the purposes of offering an amendment.
Mr. Chairman, I have an amendment at the desk.
The clerk will report.
Amendment to H.R. 4278, offered by Ms.
I ask unanimous consent that further reading of the amendment be dispensed with. Without objection, so ordered. Ms. Cheffersilis McCormick is recognized for 5 minutes for her amendment.
Thank you, Chairman Boss. My amendment would strike provisions of H.R. 4278 that would deny VA employees the right to appeal disciplinary actions to the Merit System Protections Board, or MSPB. Specifically, it would restore the appeal rights for supervisors, management officials, and rank-and-file employees, hundreds of thousands of employees who stand to lose these rights under H.R. 427. The MSPB was established in 1979 as an independent agency of the executive branch to serve as the guardian of the federal merit system. Its roots are in the Peloton Act, which ended generations of political patronage in the federal government. The act required government employees to be selected through merit-based competitive procedures and made it unlawful to fire or demote employees for political reasons. The MSPB is an independent body that hears individual employees' appeals of employment actions, including appeals of disciplinary actions. When the MSPB independently determines that an adverse action taken by an agency is unreasonable, the MSPB can issue orders compelling agencies to reverse the action and may order relief, including reinstatement, back pay, and attorney's fees. Denying VA employees access to the same objective third-party review of an agency's action that we offer other federal employees in the name of so-called accountability is simply not something we should allow. Instead, we should be protecting these due process rights to ensure that disciplinary processes are not used unfairly against VA employees. I would add that the MSPB was a hamstring for years due to the Trump administration's unwillingness to appoint board members, so cases languished as the board could not maintain a quorum of members. Now, as the board has become functional again, I think it's to serve as an important check to ensure that the merit-based principles are upheld in federal employment. I urge my colleagues to support my amendment. With that, Chairman Bost, I yield back.
Gentlelady yields back. I recognize myself in opposition to the amendment. The MSPB acts to slow down the employee's disciplinary process. The MSPB's administrative judge review and full panel review process are 2 of the 5 checks the employees have under traditional civil service authorities. These seemingly endless checks can drag out a disciplinary process for years and often lead to a toxic VA employees remaining in their position while their proceedings are dragged out. Non-supervisory employees may need these additional checks to ensure they are treated fairly, but a VA's middle management doesn't need extra protection. Talking with numerous VA union employees, one thing I hear is that the bad middle management make VA an impossible and unhealthy place to work, which costs us employees. Unlike their subordinates, middle managements are often not closely supervised, and many toxic supervisors know how to use and abuse the VA system to benefit them at the expense of their subordinates. Now, this amendment would keep the layers of unnecessary bureaucracy, which often skews the disciplinary system in favor of the bad employees. So I oppose this amendment, and I yield back. Does any other member seek to be recognized? Seeing none. The question occurs on the agreement to the Chair Phyllis. We're going to sit down someday and just figure out how to do that. Chair Phyllis McCormick Amendment number 7 to H.R. 4278. All those in favor say aye. Aye. All those opposed say no. And No, in the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
A recorded vote has been requested pursuant to committee rules. This vote will be postponed. I now recognize Representative DeLuzio for the purposes of offering an amendment.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 427.
I ask unanimous consent that further reading of the amendment be dispensed with, and without objection, so ordered. Representative DeLuzio, it is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. My amendment would strike provisions of H.R. 4278 that would apply the act retroactively to June 13, 2017, the date of enactment of the VA Accountability and Whistleblower Protection Act of 2017. There are many reasons to reject these provisions of the bill, I think. First, we should consider basic fairness. It's been more than 6 years since the original law was passed. To subject VA's workforce to a harsher set of rules and penalties with a lengthy look-back period of 6 years undermines considerations of due process. Secondly, retroactive application of this legislation would likely create a massively burdensome queue of disciplinary actions for VA to re-adjudicate. Going back and applying a different set of rules to 6 years worth of performance and misconduct would necessarily divert the attention of VA's attorneys, human resources professionals, and managers from their important work they should be focused on now, particularly ensuring the department continues to staff up in support of implementation of the Honoring Our Pact Act. Third, and perhaps most importantly, these retroactivity provisions will undoubtedly be challenged in the courts. They raise numerous constitutional questions, including possible violations of separation of powers and the Fifth Amendment's due process and takings clauses. So for these reasons, I encourage my colleagues to support this amendment. And with that, Mr. Chairman, I yield back.
The gentleman yields back, and I recognize myself in opposition to the amendment. This amendment would prevent the VA Secretary from considering retroactive misconduct or poor performance when using to restore the VA Accountability Act to hold its employees accountable. Simply put, it is an amendment where, if adopted, that the Restore VA Accountability Act became law on a Veterans Day this calendar year. A VA employee who harmed a veteran on January 1st or even November 10th couldn't even be held accountable for their actions. That's not right. Now, my team has worked carefully to ensure the Restore VA Accountability Act is constitutional. Let me say it again, is constitutional and fair. My bill would allow the VA to discipline employees for actions that have always been misconduct or poor performance. We aren't moving the goalpost, but we are giving VA the authority they need to hold people accountable for actions that have affected veterans. I oppose the amendment, and I yield back. Does any other member seek recognition? Seeing none. The question now is occurs on agreeing to the DeLuzio amendment number 3 to H.R. 4278. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the noes have it. And the amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
A vote has been requested, and pursuant to committee rules, the vote will be postponed. I now recognize Mr. McGarvey for the purposes of an amendment.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 427.
I ask unanimous consent that further reading of the amendment is be dispensed with, and without objection, so ordered. Representative McGarvey is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment would strike the entirety of Section 4 from H.R. 4278. Now, of course, we believe in accountability, and there should be accountability. The purpose of this amendment is to make sure that that accountability is being focused where we need it, at the managers at the top who are in charge of supervising and really helping the people who are just working hard every day to process these claims. The VA made clear in its testimony at the recent legislative hearing on this bill in the Oversight and Investigations Subcommittee that the department already has all the tools it needs under existing Title V and Title 38 authorities to take disciplinary actions against employees, including the rank-and-file employees. There are already disciplinary ways that those rank-and-file employees can be dealt with. This bill, however, muddies the waters and has the potential to be weaponized against the hardworking VA employees who then would have little recourse. The VA's current implementation of Title 38, Section 714 has been challenged in cases before the Merit Systems Protection Board, the Federal Labor Relations Authority, and the U.S. Court of Appeals for the Federal Circuit. The VA let this committee know, they already let this committee know, that it is incurring legal and financial risk by continuing to use Title 38, Section 714 for removing employees. I just don't think we should continue to force the VA down this path when there are other viable authorities available that serve the same purpose with less risk. So I, of course, support strengthening accountability. I do. But shouldn't that accountability start with those at the top of the organization? If we're going to talk about the notions of accountability, we should focus our attention on the enforcing authorities that are applicable to supervisors and senior executives, the individuals most directly responsible for accountability within the department, not the John Doe and Jane Doe working hard to process claims and serve our vets. So rather than doubling down on the use of Title 38, Section 714, the VA should continue to use the tried and tested Title V authorities. We would all be better served if the VA could focus on improving training for supervisors and HR professionals rather than fighting those battles in court. I think that's how we can help the workforce, and that is how we can improve accountability. I hope my colleagues will support this amendment, and I yield back.
Gentleman yields back, and I recognize myself in opposition to the amendment. The amendment would remove many of the provisions in the bill needed to hold bad employees accountable. The bottom line is that this amendment would ensure that the status quo is maintained for the most VA employees. The status quo is VA is not using Section 714 at all, and not being able to use this bipartisan authority to hold bad VA employees accountable. The status quo means that excellent VA employees who are frustrated by poor performance or misconduct that goes unchecked quit. Say that again, quit and seek other employment so we lose good employees. The status quo means veterans are not being put first. And believe me, veterans need to be put first. That's unacceptable to me, and I oppose the amendment, and I yield back. Does any other member seek recognition? Representative Van Orton.
Thank you, Mr. Chairman. I sincerely appreciate Mr. McGarvey's sincerity. It's absolutely true, and I believe you completely. I would just ask everybody on this committee if they can name a single SES from the Veterans Affairs Committee that has been fired for misconduct.
Gentleman yields back.
I yield back.
Anyone else seek recognition? Seeing none. The question now occurs on agreeing with the McGarvey Amendment number 6 to H.R. 4278. All those in favor say aye. Aye. Those opposed say no. No. The opinion, Chair, the noes have it. The amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
A recorded vote has been requested pursuant to committee rules. This vote will be postponed. I now recognize Representative Baczynski for the purpose of offering an amendment.
Mr. Chairman, I have an amendment at the desk.
The clerk will report.
Amendment to
I ask unanimous consent that further reading of the amendment is dispensed with without objection, so ordered. Representative Baczynski, you are recognized for 5 minutes on your amendment.
Thank you, Mr. Chairman. My amendment would strike provisions of H.R. 4278 that would cause this act to supersede existing collective bargaining agreements between VA and its employees. More than 79% of VA's workforce is comprised of bargaining unit employees. Procedures outlined in VA's collective bargaining agreements have been agreed upon after extensive negotiations between unions and management. Less than 2 weeks from now, Secretary McDonough and the VA's largest union, the American Federation of Government Employees, are scheduled to sign a new master agreement that has been in the works for more than 5 years. To enact legislation that would simply throw this out and all the agreements with VA's other unions out of the window is cruel and grossly unfair, given that the parties negotiated those agreements under the state of the law at the time. When Congress passes new laws, it is customary for labor and management to return to the bargaining table to incorporate these new laws into VA's collective bargaining agreements, not for Congress to unilaterally deny the workforce that right. Specifying in this bill that any collective bargaining agreements must supersede is anti-union and anti-worker. It's just that simple. As the Fraternal Order of Police expressed in its July 18th letter of opposition to H.R. 4278, and I quote, "Contracts represent an agreement between employers and employees to ensure that agency's mission, serving the needs of our nation's veterans and protecting its facilities from crime and violence, is a success. If H.R. 4278 is enacted, it would set a terrible precedent that existing contracts could be ignored and threaten the right to bargain collectively for all federal employees, not just those at the VA. If collective bargaining agreements can be set aside or ignored, then the bargaining process has no real value for employees or employers," end quote. I will also note that the committee received a letter of opposition to H.R. 4278 yesterday that was signed by 12 employee unions, including the American Federation of Government Employees, the International Association of Firefighters, and the International Teamsters Union. The provisions overriding collective bargaining agreements are among the union's reasons for opposing this bill. I urge my colleagues to support my amendment, which will strike this problematic anti-union provision from the bill. With that, I yield back.
The gentlelady yields back. I recognize myself in opposition to the amendment. In 2017, Congress passed a bipartisan VA Accountability Whistleblower Protection Act of 2017. Republicans and Democrats made the choice to prioritize veterans and kept collective bargaining requirements out of the 2017 Accountability Act. The 2017 law states, and I quote, "The procedures in this subsection shall supersede all collective bargaining agreement to the extent that such agreement is inconsistent with such procedures." You voted this, as ranking member Takano, somehow the FLRA, an unelected body of federal administrators, decided that in 2017, the law still need to be collective bargained. It was not until this year, immediately after the Biden administration, that the VA decided to stop using many of its Accountability Act authorities that the VA and its union partners agreed on at a collective bargaining agreement. Let me say it again. They agreed on it at a collective bargaining agreement. Now, some of the new members here may not know this. I was a union firefighter. I have no issues with union. My grandfather was head of the United Mine Workers Union. I've stood for the unions. No collective bargaining agreement or other bureaucratic blockade, however, should ever stand in the way of holding VA employees accountable so that our veterans don't receive the highest quality care and benefits they deserve. Now, let me ask you, are you for the veterans? Are you for the employees that are continuing to have misconduct at a level that we can't control? I'll ask each one of you as we move forward with this. This is from a union firefighter that's a union family. Where's your priority? Is it with the veterans? Or is it with the bad conduct of middle management and others that exist in our VA? Now, I oppose the amendment and I yield back. Does any other member wish to comment on the amendment? Seeing none, the question now occurs on the agreeing to the Budzinski Amendment, number 2, to H.R. 4278. All those in favor say aye. All those opposed, no. In the opinion of the chair, the noes have it, and the
Chairman,
amendment.
I call for a recorded vote.
The recorded vote is requested pursuant to committee rules. This vote will be postponed. I now recognize Representative Mervan for the purpose of offering an amendment.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 4278, offered by Mr.
I ask unanimous consent that further reading of the amendment be dispensed with. Without objection, so ordered. Representative Mervan, you are recognized for 5 minutes on your amendment.
Thank you, Chairman Bost. My amendment would require VA to establish a contract with the National Academy of Public Administration to review VA's oversight, accountability, and performance management structures. As we discussed at the Oversight and Investigation Subcommittee's legislative hearing on Chairman Bost's bill 2 weeks ago, there are many other facets to accountability and performance than simply taking disciplinary action against employees. The Academy is a congressionally chartered, independent, nonprofit, nonpartisan organization dedicated to helping government leaders address complex challenges. and I think we can all agree the challenges VA faces are complex. My amendment would require a top-to-bottom, inside-out review of VA's organizational structure, performance management process, employee professional development programs, and leadership development programs. The Academy would also examine how best practices of other federal agencies could be applied at VA. The National Academy would be required to submit its report to the House and Senate Veterans Affairs Committee within 18 months of enactment of H.R. 4278. Then, the Secretary of Veteran Affairs would be required to submit to the committee the department's views on whether it intends to implement the recommendations made by the Academy and the timeline for such implementation. The Secretary's report must also inform the committee about whether legislation is necessary to implement any of the recommended improvements. I urge my colleagues to join me in supporting this amendment, which will provide a roadmap for strengthening accountability at the Department of Veteran Affairs. And with that, Mr. Chairman, I will yield back.
The gentleman yields back, and I recognize myself in support of this amendment. Giving VA the tools it needs to hold its employees accountable would not by itself make VA the world-class organization that veterans deserve. VA also needs strong leaders, management structures which help support its excellent employees on the ground. I support Representative Mervan's amendment, which would require VA to work with the National Academy of Public Administration to study how, in addition to the provisions already included in the Restore the VA Accountability Act, VA can improve its oversight, accountability, and performance management structures. With that, I yield back. Does any other member seek recognition at this time? Hearing none, the question now occurs on agreeing to the Mervan Amendment Number 1 to H.R. 4278. All those in favor say aye. Aye. Any opinion, and all those opposed say no. In the opinion of the chairs, the ayes have it. I now recognize Representative Brownlee for the purposes of offering an amendment.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R.
I ask unanimous consent that further reading of the amendment would be dispensed with. Without objection, so ordered. Ms. Brownlee, you're recognized for 5 minutes on your amendment.
Thank you, Mr. Chairman. My amendment would add a new section to H.R. 4278 requiring the Government Accountability Office to study the Veterans Health Administration's oversight functions. When we talked about accountability, the discussion often turns, and rightfully so, to the need to protect patient safety and promote high-quality, timely care at VA medical facilities. However, GAO and VA's Office of Inspector General have frequently highlighted concerns about weaknesses in VHA's oversight of its healthcare system, including having a fragmented oversight structure. Various separate offices within VHA headquarters hold pieces of the oversight and accountability puzzle. For example, there are separate offices dedicated to risk management, medical ethics, internal audits, medical inspections, and patient safety. Yet these offices have not always had clear roles and responsibilities, and coordination and sharing of oversight findings among all these offices does not always occur. This limits the effectiveness of these oversight functions as they are not effectively working together to identify and share findings and best practices across VHA. My amendment would require GAO to examine how VHA manages and coordinates its oversight functions, how it determines the appropriate number and types of staff for its oversight functions, how VHA prioritizes its oversight work, and the extent to which VHA uses oversight findings to make system-wide improvements. GAO would be required to submit its report and recommendations to the House and Senate Veterans Affairs committees within 12 months of enactment. I believe this report will prove very informative for the committee and for VHA as we all embrace improved accountability. With that, Mr. Chairman, I yield back.
The gentlelady yields back, and I recognize myself in support of the amendment. As I mentioned before, good employees need to be supported by a strong management structure for VA to succeed. This amendment asks GAO to look at VHA's oversight functions. GAOs, all along with the IG, play a critical role in assisting congressional oversight at VA. The amendment would add GAO's Insight report to the list of provisions already included in the bill that would improve accountability at the department. It has my full support, and I yield back. Does any other member seek recognition? Representative Deal.
Mr. Chairman, I'll just point out that the VA has hundreds of GAO recommendations that they have not yet implemented. So I support the amendment, but I believe we need to take this further. Thank
Have
you,
oversight of the oversight?
Absolutely.
Right.
I yield back.
Thank you. Anyone else seeking recognition? Hearing none, the question now occurs on the agreeing to the Brownlee Amendment, number 11, to H.R. 4278. All those in favor say aye. Aye. All those opposed say no. Can the chair, the ayes have it. I now recognize Representative Mervan for the purpose of offering an amendment. You have an amendment at the desk? So for record, let me put that the Brownlee amendment was agreed to, by the way. Okay. So, Representative, you have a
Yes. Mr.
The
Chairman,
clerk
I have
will
an amendment
report.
at the desk.
Amendment to H.R. 4278.
I ask unanimous consent that further reading of the amendment is dispensed with and without objection so ordered. Representative Mervan, you're recognized for 5 minutes.
Thank you, Chairman Boss. My amendment would require VA to submit to the House and Senate Veterans Affairs Committee a report on the total costs that have been incurred arising from the implementation of the Department of Veterans Affairs Accountability and Whistleblower Protection Act of 2017. As we discussed at the Oversight and Investigation Subcommittee's legislative hearing on Chairman Boss's bill 2 weeks ago, VA has expressed frustration with the legal challenges resulting from the implementation of the 217th law and for the legal risk that would be imposed by this new version. VA has also warned the committee of potential for further litigation which could result in substantial monetary damages. My amendment would require reporting on the total costs incurred by the VA as a result of the 2017 law. VA to date has not provided the committee with the amount of monetary damages that have been or will be needed to pay out to employees wrongfully impacted or a full accounting of the amount of time that department lawyers have spent working on appeals initiated by the law before the Merit Systems Protection Board or a federal court. Before the committee endeavors to put more legislation forward, I think it only prudent that we understand the full cost of implementing the original version. I urge my colleagues to join me in supporting this amendment, and with that, Mr. Chairman, I yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. The amendment would require VA to try to quantify the cost of implementing the VA Accountability Whistleblower Protection Act of 2017. The amendment seems to suggest that it shouldn't risk passing laws that lead to better veterans' outcomes because improving the situation for veterans means rocking the boat, and rocking the boat might lead to litigation. While my colleagues seem to be prioritizing D.C. lawyers, we don't want to rewrite the employment law textbook. Like I said earlier, the status quo doesn't cut it for me. The Restore the VA Accountability Act is designed to make Congress's intent crystal clear so that it cannot be explained away in the courts. Another thing that's crystal clear is the effect of the Restore VA Accountability Act can have. In 2017, the law led to 50% increase in removal actions, which is partly led to the veteran VA-wide trust scores increasing from 59% in 2016 to 80% in 2020. That's how our veterans feel about it. Although administrative courts have done their best to undermine the 2017 law, the Restore the VA Accountability Act would ensure that these authorities given to the VA by Congress can't be taken away. Now, I oppose the amendment, and with that, I yield back. Does any other member seek recognition on this amendment? Seeing none. The question now occurs on the agreement of the Mervan Amendment number 9 to H.R. 4278. All those in favor say aye. Aye. All those opposed say no. And the amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
A recorded vote has been requested. Pursuant to committee rules, the vote will be postponed. I now recognize Representative Pappas for the purposes of offering an amendment.
Mr. Chairman, I have an amendment at the desk.
The clerk will report.
Amendment to H.R. 42.
I ask unanimous consent. Further reading of the amendment it be dispensed with without objection, so ordered. Representative Pappas, you are recognized for 5 minutes on the amendment.
Thank you very much, Chairman Bost. My amendment doesn't take anything away from the bill. It just adds a section to H.R. 4278 that would improve management training for VA supervisors, management officials, and senior executives. I think this is a common sense step that addresses the issue of accountability. This amendment would require training every 2 years for VA management on topics such as developing performance goals and objectives with employees, effectively managing employees with unacceptable performance, and training to understand disciplinary options and procedures available to supervisors. If we are to truly ensure that VA handles poor performance in a timely and effective manner, we need to ensure that managers know the rules, are aware of the disciplinary and management tools that are available to them, and fully understand their role in performance management processes. So I urge my colleagues to support this amendment, and I yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. I appreciate the efforts to ensure VA supervisors and senior executives have the training needed to keep their employees accountable to the veterans they serve. This bill introduces several good ideas that I will consider when determining whether any training requirements should be codified. More time, however, is needed to examine what training requirements might be needed. At this time, however, I oppose the amendment and I yield back. Does any other member seek recognition? Seeing none, the question now occurs on agreeing to the Pappas Amendment number 10 to H.R. 4278. All those in favor say aye.
Aye.
All those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
A recorded vote being requested pursuant to committee rules, the vote is postponed. Are there any further amendments to H.R. 4278? Hearing none. Further proceedings on this bill will be postponed. I want to thank the minority because right now we know everybody's moving around. We're going to try to change things up instead of going to the next one. We are going to actually call up now H.R. 1767, the Student Veterans Resource Act as amended. The clerk shall report the bill.
H.R. 1767.
The bill will be circulated in advance and pursuant to the committee rules without objection. The first reading is dispensed with, and the bill is open to amendments at any point. And I now recognize myself for the purposes of offering an amendment. The clerk shall report the amendment in the nature of a substitute.
Amendment in the nature of a substitute.
I ask unanimous consent that further reading of the amendment in the nature of substitute be dispensed with, and I ask that it be considered base text for the purposes of this markup, and without objection so ordered. Now I recognize myself for 5 minutes to speak on the support of this amendment in the nature of a substitute. This amendment in the nature of a substitute would make important changes to the bill to ensure that schools who participate in the GI Bill are held accountable and pay back VA if found to have committed fraud. This proposal would also restore GI Bill benefits to a student veteran or beneficiary if the school they are attending is found guilty of fraud. My amendment, in the nature of a substitute, would tighten the language to ensure that we are not going after schools for minor infractions. Even with this bipartisan change, I am still concerned that some of the language in this proposal, specifically around the VA using the Department of Education system as a trigger to determine potential GI Bill benefit restitution. We have heard concerns from all sectors of schools about this proposal. We need to ensure that all voices and stakeholders are heard and that we ensure that the bill is done correctly. Finally, this committee must empower VA to manage its veterans education programs without giving up jurisdiction to other agencies. I thank the ranking member and the gentlelady from Illinois for working with me to get this proposal to a better spot. I look forward to working with them in addressing the concerns of these institutions in the coming weeks. And I encourage my colleagues to support the amendment, and I yield back. Do other members seek recognition at this time?
Mr. Chairman, I wish to be recognized.
Ms. Ramirez, you're recognized for 5 minutes.
Thank you, Chairman Bost. From the moment I was sworn in as a member of Congress, my goal has remained unchanged: to be an amplifying voice for all of those who feel like their voice has been ignored, and to remain true to my district. That is why I am so honored to have my bill H.R. 1767, the Student Veteran Benefit Restoration Act, considered today in full committee markup. I would like to thank my colleagues on both sides of the aisle for getting H.R. 1767 this closer to the finish line. I want to especially thank Chairman Bost and Ranking Member of the Subcommittee, Rep. Levin, as well as Subcommittee Chairman Van Orden, for all of your help and your work on getting this bill to this moment. Predatory for-profit colleges must be held accountable for robbing our students, veterans, of a quality education. For-profit greed cannot continue to harm veterans. They have earned their GI Bill benefits and are deserving of a second chance and a real opportunity to pursue education should they want to. My bill will provide a permanent pathway for student veterans to have their benefits restored. This would mean that veterans from Illinois, like Army veteran Christopher Brown from Des Plaines, Air Force veteran like Andy Kemechik from Hoffman Estates, Navy veteran Brian Tario from Lyle, and Army veteran Brian Whitehead, who attended ITT Tech in Chicago, will finally have the opportunity to complete their degrees and have their GI Bill benefits restored. As I sit with my colleagues, I want to remind you that while the bill is not as expensive as perhaps I would have liked to, it is a bill that has been compromised and negotiated through bipartisanship, and I'm very proud of that. We must continue to advocate of why we're here. We must continue to advocate with impactful legislation that will uplift our communities and the 15,292 veterans in my district. I want to especially thank the organizations who have worked so hard on this issue for so long. Organizations like Veteran Education Success, Students Veterans of America, the National Education Association, and the Hispanic Association of College and Universities. I look forward to working with my colleagues across the aisle to deliver justice for the veterans back home and across the country. Our veterans have waited too long for restoration. Let's finally pass it now. Thank you, Chairman, and I yield back.
Gentlewoman yields back. Do any other members seek recognition on the amendment? Ranking Member.
Mr. Chairman, again, I'd like to thank you and your staff for working with us to get to yes. It's an issue that I've been outspoken on. I've been an outspoken advocate for years on this very same issue. I think the gentle lady from Illinois has accomplished something very significant. I congratulate her. And I wished I would have accomplished something this significant on this issue when I entered Congress. This legislation will be a game changer by ensuring that veterans will always have their benefits restored in cases that they are harmed by bad actors, and the law will now hold these bad actors financially accountable. I'd like to thank Representative Ramirez for her work on this issue. Her strong advocacy background is serving her well here in Congress, and I'm glad she's joined us on this committee. It is her leadership and dedication that has brought this bill to the markup today and one step closer to law. It is time that we hold bad actors accountable and ensure that taxpayer dollars are well spent. For too long, for-profit schools have targeted veterans because of the 90-10 loophole. This legislation is a step in the right direction in ensuring these bad actors do not leave veterans and the taxpayer holding the bag as they run away with outsized profits made through fraud and misrepresentation. I do think the committee has more work to do in the future on improving or making permanent automatic triggers to this legislation to streamline the process and ensure the administrative burden is not on the veteran. But I'm glad that today we stand together in support of this bill. There is a long way to go until this bill becomes law, but we should all celebrate that the text in the ANS includes full retroactivity. So every student veteran who lost their benefits to a sudden school closing where borrower defense was invoked by the Department of Education will have their GI Bill benefits restored. I urge adoption of the ANS, passage out of the committee, and will be calling for quick consideration on the House floor. Thank you again, Mr. Chairman, for the bipartisan work on this bill, and I yield back.
Do any other members seek recognition on H.R. 1767? No other amendments were filed. Does any member offer an amendment or to the amendment in the nature of substitute for H.R. 1767? Seeing none, the question now occurs on agreeing to the amendment in the nature of a substitute for H.R. 1767. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. I now recognize Ranking Member for Takano for a motion.
Mr. Chairman, I move that H.R. 1767, as amended, be reported favorably to the House.
The question is on favorably reporting the bill H.R. 1767 as amended to the full House. All those in favor say aye.
Aye.
All those opposed, no. In the opinion of the chair, the ayes have it. The motion is agreed to, and H.R. 1767 as amended is reported favorably to the House.
Mr. Chairman, pursuant to Rule 11, Clause 2, I give notice of intent to file minority supplemental, additional, or dissenting views on H.R. 1767 as amended.
Without objection. I now call up H.R. 3981 as amended, and the Veterans Education Oversight Expansion Act. The clerk shall report.
H.R. 3981, to amend
The
Title...
bill was circulated in advance pursuant to committee rules, and without objection, the first reading is dispensed with. The bill is opened to amendments at any time. H.R. 3981 would require schools to self-report any adverse actions to their state-approved agencies in addition to the VA within 30 days. This would ensure that more people are aware of a school's actions and the veterans are better protected from school fraud. This proposal would also require VA to create their risk-based survey database within 180 days. The VA has been slow to move in implementing of the database, even though it was mandated by Congress. And I'm pleased to see that the bipartisan changes were made at the subcommittee level just a week ago to make it possible to bring this proposal to the full committee. Now, I urge all of my colleagues to support H.R. 3981 as amended, and I yield back. Do any other members wish to comment on H.R. 3981? Representative McCarthy.
Thank you very much, Mr. Chairman. I appreciate your work on this, the ranking member, Mr. Takano, to Congressman Levin, to Chairman Van Orden. Appreciate this bill. I look forward to the bipartisan passage of this legislation. The Veterans Education Oversight Expansion Act was drafted with input from the American Legion and the National Association of State Approving Agencies, in addition to other experts and stakeholders. It is supported by a wide swath of the veteran community and makes necessary technical tweaks to better implement the Isaacson-Roe Act. This bill sends a clear message. Don't mess with our student vets and don't mess with their benefits. I urge this committee to continue standing up for student veterans and pass H.R. 3981. And I look forward to this bill's inclusion in a future floor package and a passage in the full House. I yield back.
Gentleman yields back. Does anyone else seek recognition? Ranking member?
Mr. Chairman, I would first like to thank Representative McGarvey for his work on the bill and commend another of our freshman members on the committee for hitting the ground running and doing a great job for veterans. His bill would provide additional incentives for schools to be good stewards of taxpayer dollars and ensure the proper use of Veterans GI Bill entitlements. I appreciate Representative McGarvey's work to build on the protections this committee put into law in the Isaacson-Roe package, and I urge strong support for this bill, and I yield back.
Gentleman yields back. Does anyone else seek that recognition? No amendments were filed. Does any members wish to offer an amendment? Seeing none, I now recognize Ranking Member Takano for a motion.
Mr. Chairman, I move that H.R. 3981 as amended be reported favorably to the House.
The question is on favorably reporting H.R. 3981 as amended to the full House. All those in favor say aye. All those opposed say no. In the opinion of the chair, the ayes have it. The motion is agreed to, and the H.R. 3981 as amended is reported favorably to the House.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority supplemental, additional, or dissenting views on H.R. 3981 as amended.
Without objection. I now call up H.R. 542, the Elizabeth Dole Home Care Act of 2023. The clerk shall report.
H.R. 542.
The bill was circulated in advance pursuant to committee rules, and without objection, the first reading is dispensed with, and the bill is open to amendments at any point. I now recognize Representative Brownlee for the purpose of offering an amendment. The clerk shall report.
The amendment in the nature of a substitute to H.R. 542, offered by Ms. Brownlee of California. Strike all after...
I ask unanimous consent that further reading of the amendment in the nature of a substitute be dispensed with, and I ask that it be considered base text for the purposes of this markup, and without objection, so ordered. I now recognize Ms. Brownlee for her 5 minutes to speak on support of the amendment in the nature of a substitute.
Thank you, Mr. Chairman, and I appreciate that this legislation has been brought forward today. As we previously discussed at the legislative hearing, my bill will enable aging and disabled veterans to receive the support they need to live at home. It expands several existing VA programs that are evidence-based, cost-effective, and consistently in high demand among aging veterans. Research shows aging veterans' health outcomes are better when they have the choice to stay home and receive the care and support that they need to age with dignity. Expanding access to the programs in this legislation means we can delay, if not prevent, a veteran from needing institutional care. When we support veterans staying in their homes, it means families can stay together, caregivers have the support they need, and communities remain connected and intact. This bill will also serve as the long-term solution to much of the pain around the changes to the program of comprehensive assistance for family caregivers. Since last Congress, we have fought hard to get this bill across the finish line. That is why I was pleased to see CBO's revised and more accurate score of $176 million over a 10-year period. With a more accurate score in hand, I think we can agree it is a small price to pay for providing the highest quality care to veterans who wish to age in their home. I believe it critical that we advance this legislation quickly, as many veterans are in need now. For VA programs expanded under this bill, there is no service connection requirement, only medical need. Let me be clear, any veteran with a medical need for these services should be able to get them. My bill will ensure that. In addition to expanding existing home and community-based programs at VA, this legislation will raise the cap on how much VA can pay for the cost of home care. This small but highly impactful change will serve our most vulnerable veterans with ALS or serious spinal cord injuries. Additionally, this bill will create coordination between VA home care programs, the VA caregiver program, and Medicare's PACE program. Review service gaps in VA's geriatric and extended care. Provide respite care to caregivers in VA home care programs, and create a one-stop shop on VA's website where veterans can easily navigate the home and community-based resources available to them. My amendment in the nature of a substitute makes minor technical changes to the language and includes a provision to pay for the mandatory portion of the cost. Broadly, the reforms in this bill have garnered the support of many VSOs and advocacy groups representing aging and disabled people, in part because this legislation is no half measure. If enacted, this bill will make systemic improvements to how we care for aging and disabled veterans in this country. Our veterans deserve no less. Finally, developing this bill was a bipartisan team effort, and I thank and grateful for General Bergman's leadership on this bill as well. Advocates from groups with decades of expertise like the Paralyzed Veterans of America, Disabled American Veterans, and the Elizabeth Dole Foundation worked with us to refine and perfect this piece of legislation. Specifically, I'd also like to extend my sincerest thanks to Senator Elizabeth Dole. Her tireless efforts on behalf of veterans and their family caregivers continue to be an inspiration to me. Last but not least, I really want to thank the committee staff, Elizabeth McKenzie, Sarah Dean, and Alexis McDonald. The staff has worked so very hard on this bill, and I'm not sure that there's many staff that can claim in this building that they challenged CBO and won. So these staff did exactly that. It was an amazing feat, and I am very, very grateful to them. So, Mr. Chairman, my last word on this bill is it will provide better health care at a lower cost, and our veterans will overwhelmingly want this bill. And with that, I urge my colleagues to vote yes on this bill, and I yield back, Mr. Chairman.
The gentlewoman yields back, and I want to thank Ms. Brownlee for her dedication to those veterans who only want to retain the dignity and remaining in their home with their families when they face their either service injury or even the end of life. You know, I also want to thank General Berkman for his work on this important bill as well. Now, to name the bill in the honor of Elizabeth Dole, a model caregiver and a caregiver advocate, is only fitting. The program would be supported and expanded in this legislation are needed, and they're long overdue. Now, the amendment in the nature of a substitute has my full support. Do any other members want to speak on this? General Berkman, you're recognized.
Thank you, Mr. Chairman and Ranking Member Takano. I am strongly supporting H.R. 542 and the ANS. Nearly half of the more than 9 million veterans in the VA healthcare system are 65 years or older. As our veteran population increases in age, so does their need for long-term care services and support. As many older veterans will attest, receiving care at home is often preferable to care in a clinical facility. This is especially true for disabled and elderly veterans living in rural and remote communities, like in Michigan's 1st Congressional District, long distances, not many services. Unfortunately, the VA Home and Community-Based Services, HCBS program, currently has limitations that prevent many veterans from being able to seek home care. The Elizabeth Dole Home Care Act is a common-sense, bipartisan bill that will improve and expand HCBS to support more veterans and their caregivers. This includes fixing the arbitrary cap that currently limits HCBS reimbursement to only up to 65% of what it would cost a veteran if they were being treated in a nursing home. Through this and other important reforms, H.R. 542 will protect the right of our veterans to live and receive care in the comfort of their own homes. I was proud to join Congresswoman and Ranking Member Brownlee in introducing this important legislation in both the 117th and 118th Congresses, and I urge my colleagues to support it today. With that, I yield back.
Gentleman yields back. Ranking member is recognized for comments.
Thank you, Mr. Chairman. I want to commend my colleague, Congresswoman Brownlee, for her authorship and leadership on the Elizabeth Dole Home Care Act. This ANS brings this critical work closer to the finish line. And I also want to acknowledge the leadership of General Bergman on this issue. It was a great disappointment of mine that we did not get it to the finish line in the 117th Congress. And while this bill is named the Elizabeth Dole Home Care Act, our own Elizabeth McKenzie, who led our health team, did what Chairwoman Brown, what Ranking Member Brownlee has said. It's rare to see CBO taken on and actually reasonably, in a reasoned way, not forced, but shown the way to a much, instead of billions of dollars, maybe $100 million in score. And without a doubt, we all knew that giving veterans the pathway to age in place at home, rather than being forced to go into a much more expensive institution, would save the government money. And thank you, health team, for enlightening the CBO and getting them to revise their score. VA has not been moving as fast as most states have, and shifting its investments from institutional programs to non-institutional programs. This ANS will expand access to a variety of VA programs for elderly and disabled veterans, enabling them to remain at home and safely age in place and avoid or delay admission into nursing homes and other costly institutional settings of care. In addition, this legislation will help connect veterans' caregivers to respite care and other supportive services that help them care for veterans at home. It will also improve VA's coordination with other federal long-term care programs that promote aging at home. And finally, this bill will require VA to create a website where veterans and their families can more easily obtain information about VA's home and community-based services programs and access and assess whether any of these programs may be right for them. So I strongly support this ANS, and I urge my colleagues to support it as well. Needless to say that many of us on this committee are struggling with our own worries about ourselves, but also our elders, who we wonder how we are going to take care of them and how they will be taken care of. And so with that, I'm very proud of the work this committee has done, Mr. Chairman. I thank you, and I yield back.
The gentleman yields back. Mr. Van Orton.
Thank you, Mr. Chairman. You can tell what a remarkably great bill this is, as it has turned my Democrat colleagues into fiscal conservatives. It's amazing. I want to speak strongly in support of the Elizabeth Dole Home Care Act of 2023 and this ANS. Ms. Brow, you should be incredibly proud of yourself. Giving our veterans the ability to live in dignity in the most trying times of their life, I think, is a gift. And I will tell you, this is one of the finest accomplishments, in my opinion, this committee has done so far, and I would say that this is why I came to Congress. So thank you for this, ma'am. I appreciate it greatly. I yield back.
Gentleman yields back. Any other members seek recognition?
Chairman, I wish to be recognized.
Representative Martinez, you're recognized.
Ramirez, thank you.
Sorry.
Garcia or Martinez. I got called Garcia last week. But jokes aside, I really want to recognize my esteemed colleague, Rep. Brownlee. See, now I got nervous and I didn't want to get your name wrong. For continued efforts to make home and community-based care more accessible for our veterans. That's why I'm a proud co-sponsor of H.R. 542. This past Sunday, I had the opportunity to visit in Phoenix, Arizona with the VA Secretary McDonough, and our CHC chair, and meet with about 65 Latino veterans. And as we left the conversation, we were talking about how to make sure that veterans are applying for the PACT Act benefits by August 9th. But a senior veteran, probably in his 80s, came up to me and said, "Representative, what about our aging veterans? We need so much help. We want to be able to know that we've retired with dignity." Being here 3 days later, getting to vote on a bill of this nature is the full circle that I think one of my colleagues just talked about, why we're here and why we work so hard to represent our communities in Congress. Home care and community-based care are critical resources for our aging population and for our aging veterans. Our aging veterans have distinct needs and can face unique challenges when attempting to access their health care. And it's imperative that we continue to expand access to resources for our veterans. Additionally, I know that part of the work that we continue to do and have to do is ensure that people have access to health care, everyone, and that includes every single veteran. So again, Congresswoman Brownlee, it is an honor to serve with you and to serve with every single member here in our committee. To the staff that make it possible when we think it's impossible, thank you for your tireless work. Because as you mentioned constantly, we are the ones with the name. We are the ones that people hear about, but our staff is who makes it happen. So thank you to all of you. Honored to be part of this bill. Chairman, I yield back.
Gentlewoman yields back. No other members seeking recognition. There were no amendments filed, but does any member wish to offer any amendments to the amendment in the nature of a substitute for H.R. 542? Seeing none, the question now occurs on agreeing to the amendment in the nature of a substitute for H.R. 542. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. I now recognize Ranking Member Takano for a motion.
Mr. Chairman, it's with great enthusiasm that I move that H.R. 542, as amended, be reported favorably to the House.
The question is on favorably reporting the bill H.R. 542 as amended to the full House. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. The motion is agreed to, and H.R. 542, as amended, is reported favorably to the House. Representative Takano.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority, supplemental, additional, or dissenting views on H.R. 542 as amended.
Without objection, I now call up Bill H.R. 4461, the Modernization Department of Veterans Affairs Disability Benefit Questionnaires Act. The clerk shall report.
H.R. 4461.
The text was circulated in advance and pursuant to committee rules. Without objection, the first reading is dispensed with, and the bill is open for amendment at any point. I now recognize Representative Rosendale for the purposes of offering an amendment in the nature of a substitute.
Thank you, Mr. Chair. I'd like to make a motion in the amendment in the nature of a substitute.
The clerk shall report the amendment in the nature of a substitute.
Amendment in the nature of a substitute.
I ask unanimous consent that further reading of the amendment in the nature of a substitute be dispensed with, and I ask that it be considered base text for the purposes of the markup. Without objection, so ordered. I now recognize Representative Rosendale for 5 minutes to speak in support of the amendment in the nature of a substitute.
Thank you very much, Mr. Chair. My amendment in the nature of a substitute would combine the text of my legislation, H.R. 196, the Expediting Temporary Ratings for Veterans Act, with H.R. 4461, the Modernization of VA Disability Benefit Questionnaires Act, a great bill by Congressman Luttrell. I appreciate Congressman Luttrell working on this with this important piece of legislation with me. The ANS would also make some technical changes requested by VA, the American Legion, and the VFW. Both bills would make key low-cost improvements to boost the automation of disability compensation claims. The Expediting Temporary Ratings for Veterans Act would directly help some of the sickest veterans who depend most on VA disability compensation benefits. When a veteran is hospitalized for at least 21 days with a service-connected condition or illness, the current law grants them a temporary increase in their disability rating to 100%. The bill would direct VA to expand its successful pilot program and automate these determinations wherever possible within 1 year. The technology exists to make many of these rating decisions nearly instantaneous, and the time has come to do just that. The Modernization of VA Disability Benefit Questionnaires Act would direct the VA to update the DBQs that the disability exam contractors fill out to include machine-readable data. That means the automation software could directly use the data, and there would be no need to convert the questionnaire text anymore, which has never been perfect. These bills together establish a much stronger foundation for the VA's benefits automation efforts. The committee has been working on them for over a year and appreciate the opportunity to advance them now. Thank you, Mr. Chairman. I yield back.
Gentleman yields back, and I want to thank Mr. Rosendale for his work on this combined legislation. I also want to thank him for advocating to speed up the temporary ratings for the hospitalized veterans. These low-cost technical changes can make a big difference in how quickly benefits claims are processed. They have my full support. Do any other members wish to comment on the amendment? The ranking member, you recognize.
Thank you, Mr. Chairman. Late yesterday, the committee received from VA some technical assistance on this legislation. It arrived too late to be incorporated into an amendment, but I hope we can take a closer look at it and assess whether the legislation may need to be updated to address these issues before advancing this legislation to the floor or including it in a package. Otherwise, I support the underlying policy in the Rosendale ANS to 4461, and I yield back.
Does any other member seek recognition? No other amendments were filed. Does any member wish to offer an amendment to the amendment in the nature of substitute for H.R. 4461? Seeing none. The question now occurs on agreeing to the amendment in the nature of substitute for H.R. 4461. All those in favor say aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. I now recognize Ranking Member Takano for a motion.
Mr. Chairman, I move that H.R. 4461 as amended be reported favorably to the House.
The question is on favorably reporting H.R. 4461 as amended to the full House. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. The motion is agreed to. H.R. 4461 as amended is reported favorable to the House.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority, supplemental, additional, or dissenting views on H.R. 4461 as amended.
Without objection. I now call up Bill H.R. 3581, the Caregiver Outreach and Program Enhancement Act, or the COPE Act. The clerk shall report the bill.
H.R. 3581.
The text was circulated in advance pursuant to the committee rules, and without objection, the first reading is dispensed with, and the bill is now open for amendments at any point. I now recognize Representative Miller Meeks for her proposal of offering an amendment. The clerk will report the amendment in nature of substitute.
Amendment in the nature of a substitute.
I ask unanimous consent that further reading of the amendment in nature of a substitute be dispensed with, and I ask that it be considered base text for the purposes of this markup. Without objection, so ordered. I now recognize Dr. Miller Meeks for 5 minutes to speak in support of her amendment in the nature of a substitute.
Thank you, Mr. Chairman. I'm pleased to offer an amendment in the nature of a substitute that combines the three common sense texts of H.R. 3581, H.R. 2683, and H.R. 3504. Each of these bills were reported favorably out of their subcommittee of jurisdiction. My amendment would increase access to crucial mental health resources for caregivers, provide authority for infrastructure upgrades for facilities subject to flooding at surrounding access points, and examines the VA police force impact on safety within VA facilities. The cost of this amendment in the nature of the substitute is fully offset. I'd like to thank Representatives Kiggins and Mace for introducing the bills included within the ANS. I urge all of the members of this committee to support H.R. 3581 as amended, and I yield back the rest of my time.
I thank the lady for yielding back. I want to thank Dr. Miller Meeks for her work on this combined health legislation, and I especially want to thank Representatives Kiggins and Mace for introducing bills that would provide an accessibility mental health alternative for veterans caregivers, ensuring that local access points to medical facilities are not closed due to flooding, and to make the needed steps to evaluate the force responsibility for veteran security at all VA facilities. Now, this amendment, in the nature of a substitute, offers common sense solutions, and it has my full support. Do any other members wish to comment on the amendment in the nature of a substitute for H.R. 3581? Representative Kiggins.
Mr. Chair, thank you. And thank you all for being here and taking time to talk through these important issues with us. I'm happy to be a co-sponsor of several of my colleagues' bills being discussed today, especially the ones that focus on caregivers. And I want to just take a minute to speak to the COPE Act and the couple other caregiver support girls in front of the committee today. In Hampton Roads and across the country, caregivers play a critical role in the lives of our veterans. As a geriatric nurse practitioner, I know that however rewarding it may be to provide care for one's loved ones when they need us most, it can also take an extreme emotional toll on the caregiver. I introduced the COPE Act to help address that toll by enhancing mental health resources for veteran caregivers. By ensuring these men and women can properly take care of themselves, this bill will improve the lives of our nation's heroes and solidify the support system they need to age with dignity. I'm proud to have my fellow veterans and colleagues from the other side of the aisle join me in this important effort, and I'm proud to be getting this bill one step closer to the finish line. Additionally, my colleague, Ms. Brownlee, introduced the Elizabeth Dole Home Care Act. I know we recently spoke about that, but studies show that most elderly Americans would rather age in the comfort of their own home. But home care is expensive, and due to workforce shortages and a strained health system, this bill makes home care far more accessible for our elderly veterans. I'm proud to be a co-sponsor of this proposed legislation as well. there are better health outcomes for older adults, for our veteran aging population when they age in place. So having those resources, I know facility level care is not always the best, so being able to care for a veteran at home is so important. But not only will the Elizabeth Dole Care Act go a long way to taking care of those needs, but then supporting those caregivers with things like the COPE Act is just a really important step forward. So proud to be a co-sponsor, again, of the Elizabeth Dole Act and of the COPE Act. Thank you to this committee for focusing on those issues affecting the safety of our veterans, the health of their caregivers, and the happiness of our greatest generation. We must take care of these veterans and their caregivers and their mental wellness. Thank you, and I yield back.
Gentlelady yields back. Any other members seeking? Ranking member.
Mr. Chairman, I want to thank my colleague, Dr. Miller Meeks, for offering this ANS, which includes several pieces of legislation that the Health and O&I subcommittees marked up last week. I appreciate their efforts to improve the well-being of veterans, and I hope my colleagues will support this ANS, and I yield back.
Gentleman yields back. Anyone else seeking recognition? Representative Mays.
Thank you, Mr. Chairman, and good morning. In Charleston, South Carolina, living along the coast, when it rains, it floods. When it sprinkles, it floods. So I want to thank the chairman and ranking member for allowing us to be part of the COPE Act and including our legislation in this, because flooding is a huge issue for the Ralph H. Johnson VA Medical Center, impacting our veterans to get their care, because if they can't access the facility, they cannot get the care that they need. And veterans come from all over the state to the Ralph Johnson Medical Center for their care, and it's just very important. It's easy, it's a small part, but it's going to make a big difference in the lives of our veterans, and I thank you for your leadership on this. I thank my colleagues for working with us on this as well. And the purpose of the bill is to amend Title 38, U.S. Code, to authorize the Secretary of Veteran Affairs to make contributions to local authorities to mitigate the risk of flooding so that all vets can access those facilities. So thank you, Mr. Chairman, and I yield back.
Thank you, gentlelady. Are there any amendments, any other comments, first off? Are there any amendments to the amendment in the nature of a substitute to H.R. 3581? Seeing none, the question now occurs on the agreeing to the amendment in the nature of a substitute for H.R. 3581. All those in favor say aye.
Aye.
All those opposed, no. And the impediment chair, ayes have it. I now recognize Ranking Member Takano for a motion.
Mr. Chairman, I move that H.R. 3581 as amended be reported favorably to the House of Representatives.
The question is on favorably reporting the bill H.R. 3581 as amended. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chairs, the ayes have it. The motion is agreed to, and H.R. 3581 as amended is reported favorably to the House floor.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority, supplemental, additional, or dissenting views on H.R. 3581 as amended.
Without objection. I now call up H.R. 984, the Commitment to Veteran Support and Outreach Act as amended. The clerk shall report.
H.R. 984.
The bill was circulated in advance pursuant to committee rules, and without objection, the first reading is dispensed with, and the bill is open to amendments at any point. I now recognize myself in purposes of offering an amendment. The clerk shall report the amendment in nature of a substitute. I ask unanimous consent that the further reading of the amendment is in the nature of a substitute is dispensed with. I ask that it be considered base text for the purposes of this markup, and without objection, so ordered. I now recognize myself for 5 minutes to speak in support of the amendment in the nature of the substitute. This amendment in the nature of a substitute makes technical changes to clarify the intent of the bill for the use of these grants to inform veterans of their VBA benefits. So many of our rural veterans do not have access to proper assistance with their claims and are not aware of the benefits available to them. I know this because I hear from them in my district all the time. My ANS would also include language to offer the entire cost of offset the entire cost of the bill. I would like to thank Mr. Levin and for the introducing the underlying bill to strengthen the efforts of our country and tribal VSOs and their assistance and outreach efforts. This is a vitally important and I encourage the colleagues to support the amendment. I yield back, and do any other members wish to comment?
Mr. Chairman.
Lynn.
Mr. Chairman, Ranking Member Takano, thank you so much for including H.R. 984, the Commitment to Veterans Support and Outreach Act, also known as the CVSO Act, in today's markup. I introduced this bipartisan bicameral bill with Ranking Member Pappas and Representatives McMorris, Rogers, and Finstad to improve veterans' access to benefits by authorizing grants for county veteran service officers, also known as CVSOs. CVSOs are local county government employees who are nationally accredited to prepare, present, and prosecute VA claims. They work with veterans and their families every day and are often the first to inform them about their eligibility for VA programs and services. They also help enroll veterans into the Veterans Health Administration and provide assistance on a range of benefits, including service-connected disability compensation, VA home loans, education, and job training. CVSOs will be able to use this funding to improve outreach and claims assistance, hire additional staff, and to obtain VA accreditation. In doing so, this program will strengthen economic supports, improve access to care, and enhance connectedness, key strategies that reduce risk and promote protective factors for suicide. Bottom line, the CVSO Act will ensure that veterans and their families can readily access the benefits that they have earned. It passed the House with overwhelming support in December, but ran out of time to be considered in the Senate before the end of the 117th Congress. This Congress, the Senate Veterans Affairs Committee, has already reported the CVSO Act favorably, so I'm hopeful that we can get it to the President's desk soon. So I urge my colleagues to support the bill, and I yield back.
I thank the representative. Any other members wish to be recognized? Ranking Member.
Mr. Chairman, I want to thank Mr. Levin for once again sponsoring this bill, and thank you, Mr. Chairman, for bringing it before us in markup today. Now, with the passage of the PACT Act, it is more important now than ever that our veterans are made aware of the care and benefits that they have earned. It is also vitally important that veterans have assistance in accessing all VA has to offer. State, county, and tribal VSOs fill much of that information and access gap. I especially appreciate the underlying bill's set aside for tribal nations, where this need is more acute. I have had the benefit of traveling to the Navajo Nation last year, where I learned about their unique challenges in accessing benefits and the need for resources to assist veterans who are underserved. This bill will aid and greatly aid in their efforts to serve their citizens better. Likewise, we have heard from countless VSOs in support of this bill, which will help steer veterans away from dangerous and deceitful for-profit claims preparation companies and toward reputable accredited claims assistance. So, Mr. Chairman, I will just conclude by saying that I support the NS to 984 and the underlying bill and urge my colleagues to support this measure as well.
Any other? Thank you. The gentleman yields back. Does any other member seek recognition? Seeing none? Do any members wish to comment on the amendment in nature of, well, I encourage, wait, we're way ahead. Does any member wish to offer an amendment to the amendment in the nature of a substitute for H.R. 984?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute.
I ask unanimous consent. Further reading of the amendment be dispensed with, and without objection, so ordered. Representative Levin is recognized for 5 minutes on the amendment.
Thank you, Mr. Chairman. The ANS specifies that outreach covered by the grant program may only relate to Veterans Benefits Administration benefits or similar state or tribal benefits. I'm concerned that this excludes other VA benefits, most notably health care provided by the Veterans Health Administration. CVSOs already conduct outreach on all VA benefits, and parsing out which outreach can be covered by the grant program under this bill would create additional bureaucratic burden for CVSOs, which is the opposite of the bill's intent. In fiscal year 2020, CVSOs successfully processed nearly $43 billion in claims annually for direct compensation and pension benefits for veterans. If health care and other benefits are included, that number rises to nearly $86 billion. By excluding outreach on benefits like health care from this bill, we're leaving billions of dollars on the table in benefits that veterans have earned. That's why my amendment would expand covered outreach to include all VA benefits. The goal of this bill is to improve veterans' access to all of the benefits they deserve, regardless of who administers them. I hope that we can work together towards that end as this bill moves forward. In the spirit of that bipartisan collaboration, I will withdraw my amendment, and I'll yield back.
The gentleman, I thank the gentleman for that, and the gentleman withdraws his amendment. Are there any further amendments to the amendment in the nature of the substitute on H.R. 984? Seeing none, the question now occurs on the agreeing to the amendment in the nature of substitute on H.R. 984. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. I now recognize Ranking Member Takano for a motion to report H.R. 984 as amended.
Mr. Chairman, I move that H.R. 984 as amended be reported favorably to the House of Representatives.
The question is on favorably reporting the bill H.R. 984 as amended to the House floor. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. The motion is agreed to. H.R. 984 as amended is reported favorably to the House. Representative Takano.
Yeah, Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority supplemental, additional, or dissenting views on H.R. 984 as amended.
Without objection. We will now move to postponed votes. The committee postponed further proceedings on the amendments offered by Ranking Member Takano to the amendment in the nature of a substitute to H.R. 3943. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Mr. Adewagen. Mr. Adewagen, yay. Mr. Bergman. No. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. No. Mr. Rosendale, no. Dr. Miller-Meeks. Dr. Miller-Meeks. Dr. Murphy. Dr. Murphy, no. Mr. Franklin. Mr. Franklin, no. Mr. Van Orden. Mr. Van Orden, no. Mr. Luttrell. Mr. Luttrell, no. Mr. Siscomani. Mr. Siscomani, no. Mr. Crane. Mr. Crane, no. Mr. Self. Mr. Self, no. Ms. Kiggins. Ms. Kiggins, no. Ranking Member Takano.
Aye.
Ranking Member Takano, aye. Ms. Brownlee. Ms. Brownlee, aye. Mr. Levin. Aye. Mr. Levin, aye. Mr. Pappas. Mr. Pappas, aye. Mr. Mervan. Aye. Mr. Mervan, aye. Ms. Sherfilis McCormick. Ms. Sherfilis McCormick, aye. Mr. DeLuzio. Aye. Mr. DeLuzio, aye. Mr. McGarvey. Aye. Mr. McGarvey, aye. Mr. Mears. Aye. Mr. Mears, aye. Mr. Landsman. Aye. Mr. Landsman, aye. Ms. Budzinski. Ms. Budzinski, aye.
Clerk will report. Before your count,
Excuse me. Sorry about that. Dr. Miller-Meeks. Dr. Miller-Meeks, no.
The clerk will report.
Mr. Chairman, the vote is 12 yeas and 13 noes.
There are 12 yeas and 13 noes. The amendment is not agreed to. Without objection. Hold on. You had a question? Okay. Without objection, the motion to reconsider is laid upon the table. The question now occurs on the amendment in the nature of a substitute on H.R. 3943 offered by Representative Franklin. All those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it. Now, the amendment in the nature of substitute is agreed to. Without objection, the motion to reconsider is laid on the table. I now recognize the Ranking Member Takano for a motion to report H.R. 3943 as amended.
Mr. Chairman, I move that H.R. 3943 as amended be reported favorably to the House.
All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it. The motion is agreed to, and H.R. 3943, as amended, is reported favorably to the House. Representative?
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority supplemental, additional, or dissenting views on H.R. 3943 as amended.
Without objection. The committee postponed further proceedings on the amendment number 4 offered by Representative Levin. I do that all the time. It's a problem. To H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Ms. Radowagen.
No.
Ms. Radowagen, no. Mr. Bergman. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. Mr. Rosendale, no. Dr. Miller-Meeks. Dr. Miller-Meeks, no. Dr. Murphy. Dr. Murphy, no. Mr. Franklin. Mr. Franklin, no. Mr. Van Orden. Mr. Van Orden, no. Mr. Luttrell. Mr. Luttrell, no. Mr. Siscomani. Mr. Siscomani, no. Mr. Crane. Mr. Crane, no. Mr. Self. Mr. Self, no. Ms. Kiggins. Ms. Kiggins, no. Ranking Member Takano.
Aye.
Ranking Member Takano, aye. Ms. Brownlee. Ms. Brownlee, aye. Mr. Levin. Mr. Levin, aye. Mr. Pappas. Mr. Pappas, aye. Mr. Mervan. Mr. Mervan, aye. Ms. Sherfless McCormick. Ms. Sherfless McCormick, aye. Mr. DeLuzio. Mr. DeLuzio, aye. Mr. McGarvey. Mr. McGarvey, aye. Mr. Mears. Mr. Mears, aye. Mr. Landsman. Mr. Landsman, aye. Ms. Bazinski. Ms. Bazinski, aye.
Clerk will report.
Mr. Chairman, the vote is 11 ayes and 14 noes.
There are 11 ayes and 14 noes. The amendment is not agreed to. Without objection, the motion to reconsider is laid upon the table. We now consider the committee postpone further proceedings on amendment number 7 offered by Representative Chevelis McCormick onto H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Ms. Radowagen. Ms. Radowagen, no. Mr. Bergman. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. Mr. Rosendale, no. Dr. Miller-Meeks. Dr. Miller-Meeks, no. Dr. Murphy. Dr. Murphy, no. Mr. Franklin. Mr. Franklin, no. Mr. Van Orden. Mr. Van Orden, no. Mr. Luttrell. Mr. Luttrell, no. Mr. Siscomani. Mr. Siscomani, no. Mr. Crane. Mr. Crane, no. Mr. Self. Mr. Self, no. Ms. Kiggins. Ms. Kiggins, no. Ranking Member Takano.
Aye.
Ranking Member Takano, aye. Ms. Brownlee. Ms. Brownlee, aye. Mr. Levin. Mr. Levin, aye. Mr. Pappas. Mr. Pappas, aye. Mr. Mervan. Mr. Mervan, aye. Ms. Sherfless McCormick. Ms. Sherfless McCormick, aye. Mr. DeLuzio. Mr. DeLuzio, aye. Mr. McGarvey. Mr. McGarvey, aye. Mr. Ramirez. Ms. Ramirez, aye. Mr. Landsman. Mr. Landsman, aye. Ms. Budzinski. Ms. Budzinski, aye.
Clerk will report.
Mr. Chairman, the vote is 11 ayes and 14 noes.
There are 11 ayes and 14 noes. The amendment is not agreed to, and without objection, the motion to reconsider is laid on the table. The committee postponed further proceedings on amendment number 3, offered by Representative Luzio to H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Ms. Radowagen. Ms. Radowagen, no. Mr. Bergman. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. Mr. Rosendale, no. Dr. Miller-Meeks. Dr. Miller-Meeks, no. Dr. Murphy. Dr. Murphy, no. Mr. Franklin. Mr. Franklin, no. Mr. Van Orden. Mr. Van Orden, no. Mr. Luttrell. Mr. Luttrell, no. Mr. Siscomani. Mr. Siscomani, no. Mr. Crane. Mr. Crane, no. Mr. Self. Mr. Self, no. Ms. Kiggins. Ms. Kiggins, no. Ranking Member Takano.
Aye.
Ranking Member Takano, aye. Ms. Brownlee. Ms. Brownlee, aye. Mr. Levin. Mr. Levin, aye. Mr. Pappas. Mr. Pappas, aye. Mr. Mervan. Mr. Mervan, aye. Ms. Sherfilis McCormick. Ms. Sherfilis McCormick, aye. Mr. DeLuzio. Mr. DeLuzio, aye. Mr. McGarvey. Mr. McGarvey, aye. Mr. Ramirez. Mr. Ramirez, aye. Mr. Landsman. Mr. Landsman, aye. Ms. Budzinski. Ms. Budzinski, aye.
Clerk will report.
Mr. Chairman, the vote is 11 ayes and 14 noes.
There are 11 ayes and 14 noes. The amendment is not agreed to. Without an objection, the motion is reconsidered and laid on the table. Committee postponed further proceedings on amendment number 6 offered by Representative McGarvey to H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Ms. Radewagen. Ms. Radewagen, no. Mr. Bergman. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. Mr. Rosendale, no. Dr. Miller Meeks. Dr. Miller Meeks, no. Dr. Murphy. Dr. Murphy, no. Mr. Franklin. Mr. Franklin, no. Mr. Van Orden. Mr. Van Orden, no. Mr. Luttrell. Mr. Luttrell, no. Mr. Siscomani. Mr. Siscomani, no. Mr. Crane. Mr. Crane, no. Mr. Self. Mr. Self, no. Ms. Kiggins. Ms. Kiggins, no. Ranking Member Takano.
Aye.
Ranking Member Takano, aye. Ms. Brownlee. Ms. Brownlee, aye. Mr. Levin. Mr. Levin, aye. Mr. Pappas. Mr. Pappas, aye. Mr. Mervan. Mr. Mervan, aye. Ms. Sherfilis McCormick. Ms. Sherfilis McCormick, aye. Mr. DeLuzio. Mr. DeLuzio, aye. Mr. McGarvey. Mr. McGarvey, aye. Mr. Ramirez. Mr. Ramirez, aye. Mr. Landsman. Mr. Landsman, aye. Ms. Budzinski. Ms. Budzinski, aye.
Clerk will report.
Mr. Chairman, the vote is 11 ayes and 14 noes.
There are 11 ayes and 14 noes. The amendment is not agreed to, and the motion, and without objection, the motion to reconsider is laid upon the table. The committee postponed further proceedings on amendment number 2 offered by Representative Budzinski in H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Ms. Radewagen. Ms. Radewagen, no. Mr. Bergman. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. Mr. Rosendale, no. Dr. Miller Meeks. Dr. Miller Meeks, no. Dr. Murphy. Dr. Murphy, no. Mr. Franklin. Mr. Franklin, no. Mr. Van Orden. Mr. Van Orden, no. Mr. Luttrell. Mr. Luttrell, no. Mr. Siscomani. Mr. Siscomani, no. Mr. Crane. Mr. Crane, no. Mr. Self. Mr. Self, no. Ms. Kiggins. Ms. Kiggins, no. Ranking Member Takano.
Aye.
Ranking Member Takano, aye. Ms. Brownlee. Ms. Brownlee, aye. Mr. Levin. Mr. Levin, aye. Mr. Pappas. Mr. Pappas, aye. Mr. Mervan. Mr. Mervan, aye. Ms. Sherfilis McCormick. Ms. Sherfilis McCormick, aye. Mr. DeLuzio. Mr. DeLuzio, aye. Mr. McGarvey. Mr. McGarvey, aye. Ms. Ramirez. Mr. Ramirez, aye. Mr. Landsman. Mr. Landsman, aye. Ms. Budzinski. Ms. Budzinski, aye.
Clerk will report.
Mr. Chairman, the vote is 11 ayes and 14 noes.
There are 11 ayes and 14 noes. The amendment is not agreed to, and without objection, the motion is reconsidered as laid on the table. The committee postponed further proceedings on amendment number 9 offered by Representative Mervan to H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman.
No.
Mr. Chairman, no. Ms. Radewagen. Ms. Radewagen, no. Mr. Bergman. Mr. Bergman, no. Ms. Mace. Ms. Mace, no. Mr. Rosendale. Mr. Rosendale, no. Dr. Miller Meeks. Dr. Miller Meeks, no. Dr. Murphy? Dr. Murphy, no. Mr. Franklin? Mr. Franklin, no. Mr. Van Orden? Mr. Van Orden, no. Mr. Luttrell? Mr. Luttrell, no. Mr. Siscomani? Mr. Siscomani, no. Mr. Crane? Mr. Crane, no. Mr. Self? Mr. Self, no. Ms. Kiggins? Ms. Kiggins, no. Ranking Member Takano?
Aye.
Ranking Member Takano, aye. Ms. Brownlee? Ms. Brownlee, aye. Mr. Levin? Mr. Levin, aye. Mr. Pappas? Mr. Pappas, aye. Mr. Mervan? Mr. Mervan, aye. Ms. Sherfilis McCormick? Ms. Sherfilis McCormick, aye. Mr. DeLuzio? Mr. DeLuzio, aye. Mr. McGarvey? Mr. McGarvey, aye. Mr. Ramirez? Mr. Ramirez, aye. Mr. Landsman? Mr. Landsman, aye. Aye. Aye, correct, okay. Ms. Vizinski? Ms. Vizinski, aye.
Clerk will show a report.
Mr. Chairman, the vote is 11 ayes and 14 noes.
There are 11 ayes and 14 noes. The amendment is not agreed to. Without objection, the motion to reconsider is laid upon the table. The committee postponed further proceedings on amendment number 10, offered by Representative Pappas to H.R. 4278. The question occurs on agreeing to the amendment. The clerk shall call the roll.
Mr. Chairman?
No?
Mr. Chairman, no. Ms. Radwagen? Ms. Radwagen, no. Mr. Bergman? Mr. Bergman, no. Ms. Mace? Ms. Mace, no. Mr. Rosendale? Mr. Rosendale, no. Dr. Miller Meeks? Dr. Miller Meeks, no. Dr. Murphy? Dr. Murphy, no. Ms. Franklin, or Mr. Franklin? No. Mr. Franklin, no. Mr. Van Orden? Mr. Van Orden, no. Mr. Luttrell? Mr. Luttrell, yes. Mr. Siscomani? Mr. Siscomani, no. Mr. Crane? Mr. Crane, no. Mr. Self? Mr. Self, no. Ms. Kiggins? Ms. Kiggins, no. Ranking Member Takano?
Aye.
Ranking Member Takano, aye. Ms. Brownlee? Ms. Brownlee, aye. Mr. Levin? Mr. Levin, aye. Mr. Pappas? Mr. Pappas, aye. Mr. Mervan? Mr. Mervan, aye. Ms. Sherfilis McCormick? Ms. Sherfilis McCormick, aye. Mr. DeLuzio? Mr. DeLuzio, aye. Mr. McGarvey? Mr. McGarvey, aye. Mr. Ramirez? Mr. Ramirez, aye. Mr. Landsman? Mr. Landsman, aye. Ms. Bazinski? Ms. Bazinski, aye.
Clerk shall report.
Mr. Chairman, the vote is 12 ayes and 13 noes.
There are 12 ayes and 13 noes. The amendment is not agreed to, and without objection, the motion to reconsider is laid upon the table. Although the question now occurs on H.R. 4278 as amended. All those in favor say aye. Aye. All those opposed say no. In the opinion of the chair, the ayes have it. A recorded vote has been requested. The clerk shall call the roll.
Mr. Chairman.
Aye.
Mr. Chairman, aye. Ms. Radwagen? Ms. Radwagen, aye. Mr. Bergman? Mr. Bergman, aye. Ms. Mace? Ms. Mace, aye. Mr. Rosendale? Mr. Rosendale, aye. Dr. Miller Meeks? Dr. Miller Meeks, aye. Mr. Murphy? Dr. Murphy, aye. Mr. Franklin? Mr. Franklin, aye. Mr. Van Orden? Mr. Van Orden, aye. Mr. Luttrell? Mr. Luttrell, aye. Mr. Siscomani? Mr. Siscomani, aye. Mr. Crane? Mr. Crane, aye. Mr. Self? Mr. Self, aye. Ms. Kiggins? Ms. Kiggins, aye. Ranking Member Takano?
No.
Ranking Member Takano, no. Ms. Brownlee? Ms. Brownlee, no. Mr. Levin? Mr. Levin, no. Mr. Pappas? Mr. Pappas, no. Mr. Mervan? Mr. Mervan, no. Ms. Sherfilis McCormick? Ms. Sherfilis McCormick, no. Mr. DeLuzio? Mr. DeLuzio, no. Mr. McGarvey? Mr. McGarvey, no. Mr. Ramirez? Mr. Ramirez, no. Mr. Landsman? Mr. Landsman, no. Ms. Bazinski? Ms. Bazinski, no.
Clerk shall report.
Mr. Chairman, the vote is 14 ayes and 11 noes.
There are 14 yeas and repeat that again, I'm sorry.
11 noes.
11 noes. H.R. 4278, as amended, is agreed to, and without objection, the motion reconsidered laid on the table. I now recognize Representative Berkman for a motion.
Mr. Chairman, I move that the committee report H.R. 4278 as amended favorably to the House.
All those in favor say aye. Aye. All those opposed?
No.
No. So, in the opinion of the chairs, the ayes have it. The motion is agreed to, and H.R. 4278, as amended, is reported favorably.
Mr. Chairman, I call for a recorded vote.
A recorded vote being requested. The clerk shall call the roll.
Mr. Chairman.
Aye.
Mr. Chairman, aye. Ms. Radewagen. Ms. Radewagen, aye. Mr. Bergman. Mr. Bergman, aye. Ms. Mace. Ms. Mace, aye. Mr. Rosendale. Mr. Rosendale, aye. Dr. Miller-Meeks. Dr. Miller-Meeks, aye. Dr. Murphy. Dr. Murphy, aye. Mr. Franklin. Mr. Franklin, aye. Mr. Van Orden. Mr. Van Orden, aye. Mr. Luttrell. Mr. Luttrell, aye. Mr. Siscomani. Mr. Siscomani, aye. Mr. Crane. Mr. Crane, aye. Mr. Self. Mr. Self, aye. Ms. Kiggins. Ms. Kiggins, aye. Ranking Member Takano.
No.
Ranking Member Takano, no. Ms. Brownlee. Ms. Brownlee, no. Mr. Levin. Mr. Levin, no. Mr. Pappas. Mr. Pappas, no. Mr. Mervan. Mr. Mervan, no. Ms. Sherfless McCormick. Ms. Sherfless McCormick, no. Mr. DeLuzio. Mr. DeLuzio, no. Mr. McGarvey. Mr. McGarvey, no. Mr. Ramirez. Mr. Ramirez, no. Mr. Landsman. Mr. Landsman, no. Ms. Bazinski. Ms. Bazinski, no.
Clerk shall report.
Mr. Chairman, the vote is 14 yeas and 11 noes.
There are 14 yeas and 11 noes. The motion is agreed to, and H.R. 4278, as amended, is reported favorably to the House.
Mr. Chairman, pursuant to House Rule 11, Clause 2, I give notice of intent to file minority supplemental, additional, or dissenting views on H.R. 4278 as amended.
Without objection. Okay, that concludes our markup. I want to say a special thank you to all of you for being here. I know that all of us are being called out to every way around this place this week. But let's summarize today's vote. The committee has voted to report favorably 11 bills to the House floor. The H.R. 3848 as amended, H.R. 3943 as amended, H.R. 3874 as amended, H.R. 3933, H.R. 4278 as amended, H.R. 4461 as amended, H.R. 3581 as amended, H.R. 1767 as amended, H.R. 3981 as amended, H.R. 5542 as amended, and H.R. 984 as amended. I ask unanimous consent that committee staff and authorize to make technical, clerical, and conforming changes to the bills favorably reported today. Without objection, so ordered. I also ask unanimous consent that all members be given 5 legislative days in which to revise or extend their remarks and insert extraneous material on any bill of the bills reported favorably today. Without objection, so ordered. I thank all the members, and Ranking Member, if you have any closing.
Just very briefly, I want to acknowledge the work of Elizabeth McKenzie, our staff director for our Health Subcommittee. And this will be her last day in service to our committee, and she's moving on to that other body. But Elizabeth, thank you for your service to our veterans and to us. Thank you.
Thank you very much. Thank you. And we want to thank all of the staff and without, and say thank you to them. And the Committee on Veterans Affairs is adjourned.